and welcome to the CA Inter Corporate and Other Laws revision in English only. Up till now, we have discussed the first part of the Companies Act, where we covered chapters like nature of company, the types of companies, incorporation of companies, prospectus, allotment. Now we are going to discuss the remaining part, that is debentures, deposits, management administration, accounts of company, dividend, audit and auditor. So a lot to cover in this video. These lectures are going to be in English only. I have also uploaded one lecture on Negotiable Instruments Act, and I will be uploading all the other acts in English only, especially for my students. If you are watching my video for the first time, I am CA Preeti Aggarwal and I make videos specially for you. Do subscribe to your channel TheoryMasters Learning and hit the bell icon so that you get notifications for all the videos in English only. Also visit my website theorymasterslearning.com for books, lectures and test series. So let's get started, students. We had discussed up till debentures last time, yes. So share and share capital, that part, the basic part is already covered. Let us now discuss debentures. I'm not covering the basics of debentures, like what are the types of debentures, what is the meaning of debentures, because that is not going to be asked in the exam. What we are going to cover is total exam oriented revision. Okay, so debentures, they are nothing but loan for the company. We cannot issue debentures with voting rights. Section 71. Debentures with voting rights is not allowed. Now, there was a question which was asked in the previous exams, that what if the articles allow the issue of debentures with voting rights? Even then you cannot issue debentures with voting rights. So debentures with voting rights is not permissible. The rationale behind that, the logic behind that is that you cannot place your creditors, who are debenture holders, they are creditors, you cannot place them in a much more advantageous position than the equity shareholders. So we cannot allow our creditors or debentures to take decisions for the company. That is why debentures with voting rights is not permissible, even if it is allowed by the articles. Now, you have issued debentures. Okay, the company has issued debentures. Now, debentures are generally issued for a specific purpose. Like when you raise money from the company, you have informed them that I'm raising it for this particular purpose. Like you have raised money from the debenture holders for growth and development of the company. Now the debenture holders are asking you, we can't see any growth and development, and you always tell them, the company tells them, no, it is happening, you will come to know about it in 6 months, you will see the effect, but we can't see any growth and development in the company. So law says that how will the debenture holders ensure that their money is utilized for the purpose for which it was raised? For that, we appoint debenture trustees. These debenture trustees are a liaison between the company and the debenture holder. Okay, between the debenture holders. The debenture trustees ensure that the rights of the debenture holders are protected, whether the interest is paid on time, whether the redemptions take place on time, meetings are held, the grievances are addressed. Debenture trustees will take care of all that. So why appoint the debenture trustees? It is to protect the interest of the debenture holders, to redress their grievances, like they are not receiving the certificate on time, they have not received the interest, or redemption is not happening on time. So we'll address their differences. Students, if you want to buy this chart book, these are beautiful, colorful charts which will help you to retain the concept. You can buy this from my website, theorymasterslearning.com. I'm leaving a link in the description box. Do check the sample pages of the chart book. This is a deed between the company and trustees. Okay, so this agreement is entered between the company and trustees. Now, what are the provisions? The trustee will be appointed. Yes, let's highlight the keywords. He will be appointed even before, okay, before the issue of prospectus or letter of offer, in case you are going for private placement. So the trustees will be appointed, but the agreement will be executed within 60 days of allotment of debentures. So you have decided upon your trustee. His name will also be mentioned in the prospectus or the letter of offer, that this is the person whom we are appointing as a trustee. But the agreement will be made after the debentures are allotted, within 60 days of allotment. We will create a charge in favor of the trustee. Now, if the debentures are secured, then the charge will be created in favor of the trustee, so that in case the company defaults, he can sell the security and pay the debenture holders. Trustee, if we want to remove, can be removed only with the approval of holders of at least 3/4 of the value of outstanding debentures. So if 1 lakh of outstanding debentures for the current year, 3/4. If they give their approval, only then we can remove the trustee. So these are few points relating to trustee and trust deed. Most important is when can we appoint them? They are appointed within 60 days of allotment of debentures. Who cannot be appointed as trustee? Who cannot be appointed? Yes, this list is important because case-based questions are generally asked. They will give you one main question and few sub-questions and then ask you whether this person can be appointed as a trustee or not. All right. So shareholder having beneficial interest in shares cannot be appointed as trustee. Now, who is a person having beneficial interest? Mr. X is the owner of shares. He is the owner, but he tells the company that pay dividend to Mr. Y. Mr. Y is going to get dividend. He is the beneficial owner of shares. Okay. So a shareholder or a person having beneficial interest cannot become a trustee. We want the trustee to be independent, unbiased, not having any financial relation with the company. A promoter, director, KMP, any other officer or employee, either of the company, holding or associate, cannot be appointed as trustee. So trustee has to be independent, separate person. He cannot be a promoter, director, officer of the company. He cannot have any financial relation with the company. They can't be appointed, and even their relative cannot be appointed as a trustee. Creditor, even if he has to recover 1 rupee from the company, cannot be appointed as a trustee. There was a question in the exam that we need to pay 499 rupees to a creditor. Can he be appointed as a trustee? No. Nothing has been specified. No relief has been given as far as the amount is concerned. That person cannot be appointed as trustee. Any person who is indebted to the company, associate, subsidiary, holding, or subsidiary of such holding company, like your fellow subsidiary, any person who has to pay money to the company cannot be appointed as trustee, because that person will not think independently. He will do what the company says. Let's say I have to pay 5 lakh rupees, or maybe I'll increase it 15 lakh rupees to the company. I'm indebted to the company. I will do what the company says. I will not be independent. I will not be unbiased. I cannot be appointed as a trustee. Any person who has given guarantee for the repayment of principal and interest, it means that if the surety is giving guarantee that, "Arey, don't worry, debenture holders, company will pay the money, I am giving guarantee," that person cannot be appointed as trustee. You will never say against the company. Any person who has pecuniary relation, pecuniary meaning is financial, monetary. Any person having financial or monetary relation with a company amounting to 2% or more of its gross turnover or total income or 50 lakhs or any other higher amount as may be prescribed, whichever is lower. Ma'am, we did not understand anything. Let us break and understand. If you are having interest, financial interest of 2% or more of its gross turnover or income, so what we will do is, step number 1, we will calculate 2% of the gross turnover or total income. Compare that, step 2, with 50 lakh rupees or any other higher amount as may be prescribed. Nothing has been prescribed. So 2% of gross turnover or total income, compare it with 50 lakhs, whichever is lower. Let's say that 50 lakhs is coming lower. So if you have financial relation of 50 lakhs or more, then you cannot be appointed as a trustee. Either in the financial year, current financial year, or immediately to preceding financial year, you cannot be appointed as a trustee. So this list is important for you. Please memorize this. Then we have who can, okay, after that we have the creation of debenture redemption reserve. Now, debenture redemption reserve is a reserve which is created for repayment, for redemption of debentures. See, when you have to redeem debentures, you need actual money. So law says that you keep aside some money so that you can use it for redemption of debentures. Companies Share Capital and Debenture Rules 2019. You need to remember the name of this rule. It says that DRR can be created out of profits available for dividends. So can I say that they are referring to free reserves? Free reserves are those which are available for distribution in the form of dividend. We can use that. Limits are as follows. Now, there is something called as DRR and there is something called as DRF, that is Debenture Redemption Fund. DRR is created out of the reserve, but that is not actual money. DRF refers to actual money which you're keeping in a separate bank account, which can be utilized only and only for redemption of debentures. Now, please memorize this table, because otherwise if you read the provisions in the module, they are very, very confusing. This table has actually simplified the entire section. All India financial institution. So if you are an all India financial institution, which will include your Exim Bank, that is Export and Import Bank of India, NABARD, SIDBI, NHB, that is National Housing Bank. These are all India financial institutions regulated by RBI. You need not create DRR, because there is very low risk of default. They are all regulated by RBI. If you are a public financial institution, you had studied this in section 2, clause 72 of the Act. If you are a public financial institution going either for public or private placement of debentures, yes, DRR is required, but same as for NBFC. But you will realize that till today, as of now, NBFCs are not required to create DRR. In case of listed company, except one, means except these, okay? In case of other listed companies, if they are going for public issue, this will also include listed NBFC or HFC. DRR is not required, but DRF is required. That is Debenture Redemption Fund. How it is to be created, we will see later. In case you are going for public issue of other listed companies other than NBFC or HFC, DRR is not required, DRF is required. If you're going for private placement and listed NBFC or HFC, DRR is not required, DRF is required. Private placement of other listed companies. Now, this seems very confusing, but it is very simple. In case of, I'll highlight listed NBFC or HFC, you go for public issue or you go for private placement, DRR is not required, DRF is required. If you go for other listed companies, okay, in case of other listed, I'll just erase this. In case of other listed companies, okay, I'm highlighting this other listed companies, DRR is not required, DRF is required only in case of public issue, not required in case of private placement. This is how you will remember. So these 2 points are related, and these 2 points are related, these 2 provisions. So over here it is required in case of public issue, but not required in case of private placement. Now, how will you create DRF? That also I have explained below. In case your year is, let's say for example, 1st April 2020 and it ends on 31st March 2021, then the deposits which are maturing during this period, you have to create DRF of 15% of the deposits maturing during this period. So let's say for example that the debentures maturing during this period are rupees 1 lakh, the 15% of that will be created in the form of DRF. You need to deposit that amount in these scheduled bank or securities of the government by 30th April every year. Okay, so by 30th April 2020, we will deposit at least 15% of the amount in the investments or deposits with any scheduled bank, unencumbered securities of the central or state government, of the Indian Trust Act, encumbered bonds, unencumbered bonds, sorry. So if you don't remember all these, if you're not able to remember everything, then it is fine if you just write that we can deposit that amount in the, scheduled bank or maybe securities of the government. All right. Even that is sufficient. Now, in case of unlisted companies, okay, in case of unlisted companies, except the one stated above, that is All India Financial Institution, if you are an unlisted NBFC or HFC, you are an unlisted NBFC or HFC, then no, you are not required to create DRR and DRF. But any other unlisted company other than above, yes, you need to create DRR, which will be 10% of the outstanding debentures. This is just a reserve. You also need to create 15% DRF, but that is only when you go for public issue. Okay, when you go for public issue. No DRF is required by these unlisted companies if they are offering securities through private placement. So students, you need to go through this table. If you want, you can go through it once again. It is a very simple table. You will understand everything from this table itself and you can easily write this in the exam. So that is about DRR and DRF. And with this, we also come to an end of the unit on debentures. Now let us quickly discuss charge. Charge was not defined in the Companies Act 1956. Did you know that charge was defined for the first time in Companies Act 2013? Earlier, they would only say charge includes mortgage. Now, they have a proper definition of charge. Interest or lien, which is created on property or assets of the company or any of its undertaking, both as or maybe both as security, and it includes mortgage. So, what is the meaning of charge? Charge is nothing but interest or lien, which is created on assets or property of the company or any of the undertakings, or both. Undertaking means it is an association wherein you have investment. So you may have any interest or lien on the assets of the company. You have a charge, means the asset has been given to you as security, and it also includes mortgage. Now there are different kinds of charges. We have fixed charge and floating charge. Fixed charge means a charge which is created on a particular asset which is not of fluctuating nature. The amount remains fixed. It is created on some specific or identifiable property, or a property which can be identified. You cannot deal in that property till the property is encumbered. You cannot sell it, you cannot deal in that property till it is encumbered. But in case of a floating charge, the amount keeps on fluctuating. Let's say, for example, you have given your you have given your stock or debtors as security. The amount of stock keeps fluctuating. The company is free to deal in that stock. They can buy more stock, they can sell it. But in case they sell, they may, of course, they will obviously buy more stock. The charge will automatically be created on the stock which is also bought. Fixed charge, if you have created on a particular asset, you cannot sell it except with the permission of the charge holder. But floating charge, yes, that can be freely bought, it can be sold. If you sell, the person who buys it will get it free of charge. Okay, there will not be any security on that. You may buy more stock, you may incur more debts, you may have more debtors. The charge will automatically be created on that. Now what if the charge holder violates, okay, the company, it violates the terms of charge. It violates any term, like you have not paid the principal amount, you have not paid the interest on time. In that case, or maybe you have not complied with any other condition. So in that case, the company, if it violates any terms or it ceases to carry on business, it is not insolvent, it has not liquidated. You're just not doing business. In that case, the creditor is worried. He feels that you are not in a position to repay his money. So in that case, the floating charge may crystallize into fixed charge. What is the meaning of crystallization? It means that you can no longer deal in that security. The creditor will sell the security and recover his debt. The charge has crystallized. It means that the floating charge has now become fixed charge. In case of liquidation of the company or default in paying the payment of principal or interest, violation of terms can be any terms or conditions on the basis of which charge was given. On the basis of which loan was given. So under these circumstances, the charge crystallizes. Next, we have registration of charge. Law says that every charge must be registered, whether it is made on movable property, immovable, it may be a pledge. Every charge must be registered. Now, what is the logic behind this? Let's say that you are a creditor and you have agreed to give loan to the company against security of an asset. You ask the company whether the asset has been encumbered previously. They deny. Now, as a creditor, you don't have any means to verify whether the company is speaking the truth or they are lying. The company is saying that no, the asset is free, but they have already charged that asset earlier. So law says that the creditor should have some means of knowing whether the asset is free or it is already encumbered. That is why every charge has to be registered. So the creditor, before giving loan to the company, will go to the ROC, or you can now go to the website of MCA. From there, we will check whether the charge is whether that asset is encumbered or not. Now, this is possible only when every charge is registered. So the company will register every charge that it has created, and once the charge is registered, it becomes an information in the public domain. It means the creditor, while before entering into contract with the company, must verify the register of charges. If he fails to do so, then he will have to blame himself for his negligence. It is assumed that if you are entering into contract with a company, you must have gone through the register of charges. This is again very important provision. Every person acquiring property or assets of the company shall be deemed to have notice of the charge from the date of registration of such charge. So in case you are buying any asset We will assume that you are aware whether the asset is charged or it is free. Let's say that a company sold a building to Mr. A. The building was already charged. Okay, it was subject to a charge. Now Mr. A bought the building. At the time of registration, he realized that the building is subject to a charge. Can he blame the company for not revealing that information? No. You are supposed to inquire whether that building is charged or not. Once the information of charge is sent to the ROC, we will assume that every person is deemed to have notice right from the date of registration. If you do not, if you lose money or if the company cancels your contract, you will have to blame yourself for negligence. Can be asked as a case-based question. Company's register of charges. The company will maintain register of charges at the registered office of the company. Just like ROC, the company will also maintain a register. Entries will be made for creation, modification, and satisfaction of charge. It will be authenticated by director, secretary, or any other authorized person by the board, in case you don't have a company secretary. Now, the company will also maintain a register of charge. Entries will be made by the employees, but it has to be verified. It has to be checked by director, secretary, or any person authorized by the board, and it will be preserved for 8 years from satisfaction. Satisfaction means that once your amount has been paid off, once the asset is clear, you need to inform the ROC that the charge is satisfied, the asset is no longer encumbered, and you will have to preserve the register for 8 years from satisfaction. Let us also go through the provisions regarding satisfaction of charge. Once you have repaid the debt, okay, once the asset is free, you will inform the ROC. When you inform the ROC at the time of creation or modification, it is your duty to inform the ROC also at the time of satisfaction. So we will inform the registrar within 30 days of payment. The ROC, like if you forget, they may allow you 300 days of extension from satisfaction. So in case you fail to inform them about the satisfaction, you need to inform them by filling form CHG4. And if you fail to do so, then they will allow you to file that extension within 300 days from satisfaction. ROC will then send a show cause notice to the charge holder, confirming whether the charge has actually been paid, whether your debt has been paid. Is the asset free now? Now, show cause notice will not be sent when the charge holder has signed that CHG4. So it means that he is giving his consent that yes, the charge is satisfied. Otherwise, we will have to send him a show cause notice that confirm whether you have actually received that money. Otherwise, do you have any reason to object? If yes, then tell us now. Otherwise, we will satisfy the charge. The registrar to make entry for satisfaction in the register of charges. So registrar will now satisfy the charge and that will finally be closed. Important for exam, extension of time. Now, every charge must be registered, but within what time? Charge must be registered within 30 days of creation. But what if I am a lazy company? I fail to register the charge within 30 days. If the charge is created, students, before 2nd November 2018. Now, what an odd date, no? This was the day on which the ordinance was passed. Certain amendments were made over here. If the charge is registered before 2nd of November 2018, but then you have not registered it within 30 days, then what is the extension given to you? Company will apply to the registrar and the registrar will allow the charge to be registered within 300 days of creation. So can I say that the charge is created and I ideally need to register it within 30 days? If I fail, then I will get 300 days from creation. So all the dates are calculated from creation. Now, the last day to register is 6 months from 2nd of November. It means that if you fail to register even within those 300 days, now you will get time only of 6 months from 2nd of November. It means that you can register by 2nd May 2019. Now you may think that, ma'am, what if my charge was created on 31st of August 2018? You are saying that I should have registered within 30 days, but I failed to do so. So I should get another 300 days. But that 300 days will go beyond 2nd May. No, that is not possible. 2nd May is the last day. So your last day will be considered as 2nd May. You will not get the extended time limit of 300 days. So 300 days or 2nd of May, whichever is earlier. But what if the charge is created either on or after 2nd November, but it is not registered within 30 days, then the company will apply to the ROC. A declaration will also be filed. A declaration will also be filed with the ROC, signed by the company secretary or director, along with the additional fees. So the company shall apply to the ROC with a declaration signed by the company secretary or a director, along with the additional fees, giving reasons as to why we were not able to register the charge within 30 days, seeking further extension. So ROC will grant extension within 60 days from creation of charge. So can I say that from creation, we originally now get only 30 days, and if we fail, then we will get 60 days from the date of creation. So the days are always calculated from creation. Last day will be further 60 days on the payment of ad valorem fees. What does it mean? Now, you have originally 30 days for registration. If you fail to do so, then you get 60 days from creation on payment of some additional fees. I'll highlight that. But what if I fail? So I created a charge. I should have registered within 30 days, but I failed to do so. So from creation, now I get 60 days. This I can do so on payment of additional fees. Okay, additional fees. But what if I fail to register even within that extended time of 60 days? Then I get further 60 days from the day on which this expires. Okay, so the day on which that 60th day expires, I get another 60 days, but now I have to pay ad valorem fees. Ad valorem means it is based on the value. So depending upon the value of charge, a certain percentage will have to be paid as fees. So you can get another further extended time limit of 60 days. If you remember the provisions in this table, I think it will be very easy for you to remember all the provisions. And with this, we also complete the chapter on charge. Next, let us discuss public deposits. Acceptance of deposits. Now, deposits serve as a very good medium of raising finance by the company, but the company can also raise money through issue of shares, debentures, go to the bank for loan. Why raise money through the help of deposits? Now, shares, if you issue more shares, you're diluting the holding of the current shareholders. We don't want to do that. Debentures, they have separate requirements, and they are generally secured in our country. So maybe the company doesn't want to raise debentures, and debentures are generally for short to medium term requirement. Now, if you go to the bank, they raise many covenants, and there are so many conditions which they impose. They want a lot of security. So banks are actually the last resort for the company. Deposits serve as a very good medium of raising money by companies, but in Companies Act 2013, only eligible companies can accept deposits from the public. See, private company anyways cannot go to the public. Public companies could raise money through the help of public deposits, but after 2013, only eligible companies were allowed to raise deposits from the public. But what about the companies which are not eligible and they have existing deposits? Can they renew it? No, they will have to return back the money to the depositors. Deposits, let's see how they are defined. It includes any receipt of money by way of deposit or loan or any other form by the company. So by writing any other form, they're actually widening the scope of the definition. Deposits do not include, yes, this is important for exam. What is meaning of deposit? I don't think that will be asked in the exam. But what is not included in deposit, that is important. So they will give you a main question that there are 2 or 3 sub questions. You have to decide whether it is deposit or not. In case of institutions, okay, I have classified the entire theory into different parts. Any money received from the government, either central or state government, maybe in the form of grants, or any money received, that is not considered as deposit. Money received from local authority like municipality, that is not considered as deposit by the company. The provisions of deposits which we are going to study, they will not apply. Any other source whose payment is guaranteed by the government, so government is giving guarantee, there is no scope for default. Foreign government, any money received from the foreign government, banks, institutions subject to FEMA rules. Any money received from the bank, that is in the form of loan, it is not considered as deposit. Public financial institutions or any other companies. So money received from these institutions will not be considered as deposit. Do we need to remember all this? Yes. Instruments, money received from commercial paper. Now, what is the meaning of commercial paper? It is again a source of finance, but by companies having a good reputation in the market, they are generally unsecured. So the companies having good reputation or goodwill in the market can, on the basis of that goodwill, raise money from the public. It is generally in the form of it starts from 5 lakh rupees. And commercial paper is again a short-term requirement of money by the company, which is fulfilled. Commercial paper, it has separate rules. It is not covered in the under the definition of deposit. Any money received like subscription amount, application money, that is not considered as deposit. It is money towards the nominal value of shares. On receipt of such money, this is an explanation for the above provision. If the securities are not allotted within 60 days and the amount is not refunded within the next 15 days, then the amount is treated as deposit. So you have received subscription, that is the application money, but minimum subscription is not people have not subscribed for that. In such a case, if the shares are not allotted within 60 days, you have not received the application money within 30 days, then in that case you will have to return the money within 15 days from the closure of the issue. And if you fail to do so, you will have to return it along with the interest at 15% per annum. If you fail to do all that, then it will be considered as deposit. Okay. Bonds, debentures, compulsorily convertible debentures, they are all considered they are not considered as deposit. Okay. So bonds, debentures, compulsorily convertible debentures, which will be converted into equity on the expiry of certain period of time, that is not considered as deposit. It is debentures. And yes, compulsorily convertible debentures are sometimes, for under certain circumstances, considered as equity also. Now, these debentures, they may be secured by a first charge on the asset or a charge ranking pari passu with the first charge. Now, this is the requirement of debentures. In case these requirements are complied with, then the debentures will not be considered as deposit. Otherwise, they may be considered as deposit. So, debentures should have a first charge on the security. First charge means the asset will be sold and first it will be paid to these debenture holders. First, their liability will be satisfied. Or you may be having a charge ranking pari passu, means on the same footing, on equal footing as the first charge holder. Compulsorily convertible debentures should be converted into shares within 10 years. If they are not convertible within 10 years, if they go beyond that, then they may be considered as deposit. Another requirement is that the amount of these bonds or debentures should be less than the market value of asset. This simply shows that the debentures have to be fully secured. The amount of bonds, let's say, is 1 lakh rupees, but the amount of security which you give should be more than rupees 1 lakh. This simply shows that your debentures should be secured debentures. If they are secured, then they will not be considered as deposit. Non-convertible, yes, this is important for exam case-based. Small question was asked in the past. Non-convertible debentures, unsecured and listed on the stock exchange, they will not be considered as deposit. So what are the key words over here, students? They should be non-convertible debentures. Okay, so this is the keyword, non-convertible. Non-convertible means they are not converted into equity, they will be redeemed. Unsecured, yes, they should be unsecured and listed on the stock exchange. So if these three conditions are satisfied, what is the first one? They should be non-convertible. What is the second one? They should be unsecured. And the third requirement is they should be listed on the stock exchange, then it will not be considered as deposit. Persons, any amount received from the employees, but less than, this is important, less than their annual salary in the nature of, again this is important, non-interest bearing security deposit, then that is not considered as deposit. It is not included in the definition. But what if I receive money which is more than the annual salary of that person, then that will be considered as deposit. It should be in the nature of non-interest bearing deposit. So some money is given by the employee, maybe as a security deposit, that I will perform the duty and in case I default, or sometimes when they send you abroad for some assignment, they may ask you to give some non-interest bearing deposit. So the company is not going to pay you deposit, not going to pay any interest. You will give them a security deposit, and then when you return back, that deposit will be returned to you. So amount received from employees, that is not considered as deposit. Any amount received from the directors and relative of directors of a private company, that will not be considered as deposit. See, you're not allowing the companies to accept deposit from the public. So from where will they raise money? Private company can either raise money from the members, or private company can also raise money from the directors, but a private company can also raise money from the relative of directors. So they have many options. In case of a private company, you can raise money from the members, you can raise money from the directors, and you can also raise money from the relative of directors. But the only requirement is that they have to give a declaration. Okay, directors and their relatives, they have to give a declaration that the money which they are giving it is out of their own funds and not borrowed funds. Otherwise, what will happen? We are allowing the directors to invest money. They may borrow money from outside and then contribute it in the company, saying that yes, this is my money only. So if you are claiming that, then you have to give a declaration. Give a declaration that whatever money that you are giving to the company is out of your own funds, not borrowed funds. Then it will not be considered as deposit. In case of a public company, you cannot accept money from the relative of directors. You can accept money only from the directors. So a public company, it can accept deposits from the directors. And if you are an eligible public company, then you can also accept the deposits from public also. Okay. The director of the company or the relative, in case of a private company, they must declare that the amount which they have contributed is from their own funds and not borrowed funds. Sometimes money is brought in the business by promoters because it is a bank stipulation, it is a bank's condition that we will give you term loan only on the condition that the promoters also contribute some money, they deposit some money in the company. That money which they have received is not considered as deposit. But after the loan is repaid, and if that money is still lying in the company, then that promoter's money is considered as deposit. Non-interest amount which you have received as trust. Trade advances, yes, this is important. For exam, a question can be asked on this. Trade advances for supply of goods. You have received money for supplying of goods. You have received something in advance for supply of goods. That will not be considered as deposit, provided the advance is appropriated against the goods within 360 days of acceptance. It means that after you have received the deposit, you should actually supply goods within 365 days of receiving the deposit. Then it will not be considered as deposit. Otherwise, if there is a delay, then that amount which you have received as advance, that will be considered as deposit. It is important for case-based question. Now, what are the rules? We have section 73. The heading says that the company is prohibited from accepting deposits from the public. Now, a private company cannot accept deposits from a public. Even a public company cannot accept deposits from public unless it is an eligible company. So if we are not accepting deposits from the public, from where will we raise money? Law says that you can raise money from accepting deposits from the members. You can go to the members and the members can give you money. The company may accept deposits from the members, but if they comply with the following conditions. The first condition is that we will issue a circular informing the members that yes, we are accepting deposits from members, and in case you wish to give money to the company, you can do so. So they will issue a circular mentioning the financial position of the company, the credit rating obtained by the company, the number of depositors, the number of outstanding deposits at the time of acceptance. So what are the depositors that are still outstanding? All that information will be given to the members. We will also create a deposit repayment reserve. Okay, deposit repayment reserve, like how we created CRR, okay, and debenture redemption reserve. Similarly, you will create a deposit repayment reserve. This money is to be utilized for repayment of deposits. Okay, what is the specific purpose? It is to be created for repayment of deposit. It will be amount deposited in a separate bank account. Let us see what conditions, what are the provisions for creation of this deposit redemption reserve. Now, the company shall, on or before 30th April each year, deposit at least 20% of the amount of deposits maturing in the following financial year. So let's say that you're in the financial year 21-22. So on or before 30th April 2021, you have to deposit at least 20% of the amount of deposits maturing in the following financial year, that is before 31st March 31st March 2022. So the amount which is maturing before that date, 20% of that will be created in the form of deposit repayment reserve. The company should not have defaulted in repayment of the deposits accepted earlier. So you should not have defaulted in repayment of the deposit which you have accepted earlier, that is before the commencement or after the commencement of this act. And in case a default is occurred, at least 5 years have elapsed since that default was remedied. Repayment of deposit should be made along with interest. So we will repay the deposits along with interest. Now, company has accepted the deposit before commencement of this act. Only eligible companies can accept deposits now. So what about the deposits that we had accepted earlier? That you will have to repay back. The company shall repay the money within 3 years from the commencement of this act or the due date of deposit, whichever is earlier. So the act commenced on 2013. So within 3 years, that is before 2016, you should have repaid. Or if the due date fell earlier, okay, it was earlier, then the repayment should have been made and you cannot renew these deposits. But it is not possible for the company to arrange for so much money. That is why some further extension can be granted by the tribunal if an application is made by the company. So the company will explain that it is not possible for us to repay the deposits. That is why the tribunal may grant certain extension. The company will pay heavy penalties for non-compliance and the penalties are mentioned hence. Section 76, yes, important for exam. These provisions are important. Only an eligible company, and who are eligible? They are certain public companies. Please remember, private companies cannot go to the public. Certain public companies, if your net worth is more than 100 crores, if the turnover is at least 500 crores, and you have obtained the prior consent of the company by passing a special resolution in the general meeting, then yes, you can accept deposits from the public. So who are eligible? If your net worth is either more than rupees 100 crores or you have turnover of at least 500 crores, then in that case, by passing a special resolution, you can accept deposits from the public. In case of any contravention, in complying with the provisions of section 73 to section 76, the company will be punishable for fine, which is minimum 1 crore rupees, which may extend to twice the amount of deposits, whichever is lower. 1 crore rupees or the amount or twice the amount of deposit, whichever is lower. It may extend to maximum rupees 10 crores. Officer will be punishable for imprisonment up to 7 years and fine of rupees 25 lakhs, which may extend to rupees 2 crores. Do we need to remember this provision? Yes, section 76A is important for exam. If there is any willful offense, willful means you have an intention, you have a guilty mind, you have done it on purpose, then it shall attract the provisions of section 447. Okay, so students, you need to remember this. I have simplified the provisions for you. I have put it in a tabular form. It is easy for you to remember. Very important, the limits within which you can accept deposits from the public. If you are accepting deposits from members under section 73, now you cannot go to the public, only eligible companies can. So the only source is you can accept deposits from the member. The total amount of deposits should be less than, the pen is not working. Okay, so I'll not highlight it. I think the charging got over. It's not working. Okay. In case the amount of deposits you're accepting from the members, then it should be less than, the total amount should be less than 35%, okay, of the paid up capital, free reserves and securities premium. When I say the word total, it means that the deposits that you are accepting now, as well as the deposits that you have accepted earlier and you have not repaid them. So new plus outstanding, they should be less than 35% of the total paid up capital, reserves and securities premium. If you are an eligible company and you are accepting deposits from members, then the total amount of deposits, that is new plus outstanding, should be less than 10% of the paid up capital, reserves and securities premium, and the amount that you can accept from the public, old as well as the outstanding, should be less than 25% of the paid up capitals, free reserves and securities premium. So total, it should be less than 35% from members as well as outsiders. If you are a government company, then the amount of deposits that you have accepted, new plus outstanding, should be less than 35% of the paid up capital, reserves and securities premium. So these limits are important. Please remember them for the exam. And in case a question is asked like when can we accept deposits from members or public, you need to mention these limits also. I have not given them separately, I have given them together so that it is easy for you to remember for exam. So with this, students, we complete your chapter on deposits. Next, let us discuss management and administration. management and administration. In this unit, we are going to cover sections 88 to 91 and also section 95. We are going to cover annual return from 92 to section 94, meetings discussed under section 96 to 102 and also section 121. Then we have requisites of calling a meeting, that is section 103 to 120, which will cover the provisions of quorum, proxy, and you will also study types of registers. Basically, this chapter contains information provisions relating to conducting of meetings, various registers to be maintained, and what are the requirements for conducting a valid meeting. First, let us discuss the types of registers to be maintained by the company. Every company will maintain a register of members, whether they stay in India or outside India, and this will be maintained under MGT 1. What are the details that you will mention in the register of members? So it contains information of each class of equity and preference shares held by them, either staying in India or outside India. We have to show it separately in the register. Details such as the name, address, occupation of the member, number of shares held by him, number of shares transferred by him, transmission, the date of transfer, the price, the face value at which he had purchased the shares, the date on which he became a member, the date on which he ceased to be a member. All the details relating to a member will be mentioned in the register. You can also maintain a foreign register if it is authorized by your articles. So foreign register can be maintained, but within 30 days you have to inform, within 30 days of maintaining the register, you have to inform the ROC that you are maintaining the register in form MGT 3. So you have to give a notice to the ROC giving him the place where the register of foreign members is situated. And that foreign register, that notice will be given to the ROC specifying the place where the foreign register is situated. And that notice will be given in form MGT 3. The register of members, if you are not maintaining a foreign one, the register will be maintained at the registered office. You can also keep it at some other place if you find it more convenient for better administration, saying that no, it is better that we keep it at some other place because the registered office is congested, or it is too small, or maybe the other place is it is strategically located. So that is not a problem. You can keep it at any other place within the same city, town, village where the registered office is situated. Or you can also keep it at some other place other than the city, town, village where the registered office is situated, but more than 1/10 of the total registered members reside. This limit is important for case-based question. I repeat, you can keep it at the registered office. You can also keep it at some other place, but within the same city, town, village where the registered office is situated. You don't want to keep it in the same city. You want to keep it in some other place other than the city, town, village where the registered office is situated. Then you can do so if 1/10 of the members who are entered in the register, they reside. We will have to maintain a register of debenture holders and other security holders. This will be maintained in form MGT 2. Okay, so the format, the details which are to be filled is given in form MGT 2. Where will you keep the registers and the annual return? Registers, annual return, they will all be kept at the registered office of the company. This is the place where the books are maintained, communication takes place. Can they be kept at any other place? Yes. If more than 1/10 of the total members entered in the registers reside, you have to pass a special resolution in the general meeting. So we have mentioned that point earlier also. By passing a special resolution, you can keep it at a place where 1/10 of the total members entered in the register reside. Again, this is important for case-based question. One very important provision, section 92, very frequently asked in the exam. There were attempts wherein question was asked in every 3 consecutive attempts. I have seen every 3 consecutive. Okay, so they have asked in one particular attempt, next attempt again, then third attempt again they have asked, and in one particular attempt they have asked 2 questions on section 92. So you have to memorize the provisions. Section 92, annual return, this is just a compliance requirement. It's just a compliance. You have to file a form, that is form 7, which contains financial as well as non-financial information. When is it to be filed? The annual return will be filed with the ROC within 60 days from the date on which the annual general meeting is held. So it is a compliance requirement that once you have held the annual general meeting, within 60 days you have to file an annual return of the company. Penalties are imposed if you don't file the annual return. When AGM is held, you have to file within 60 days. But what if the AGM is not held in that particular year? Then law says you need to still file the annual return within 60 days from the date on which the AGM should have been held. Okay. Normally, the annual general meeting is to be held within 6 months from the closure of the financial year. I'm talking about the subsequent meeting. So the last day for holding the annual general meeting is ideally 30th September of every year. But then there are so many other criteria which you need to satisfy. The gap should not be more than 15 months and it should be held in every year. So 6 months, within 6 months from the end of the financial year, you should have actually held it. But what is the last day on which you should hold the meeting? From there, within 60 days, you have to file the annual return and also state the reasons for not holding the annual general meeting. Also mention why you were not able to hold the annual general meeting. All right. So can this be asked in the exam? Yes, mostly for MCQ. All right. This can be asked for MCQ. What is mentioned in the annual return? As I already informed students, this is just a compliance requirement. It contains both financial as well as non-financial data. Company's registered office, where is it situated? What is the principal business activity? What is the main source of activity? What is details of holding subsidiary associate companies, details of shares, debentures and other securities, and also the shareholding pattern, the promoter group, non-promoter group, the members, debenture holders, promoters, directors, key managerial personnel, meeting of members, class, board and other various meetings. So when was the meeting conducted? What was the date of the meeting? How many people attended the meeting? What was the attendance? When was the meeting held? Number of meetings that were held, remuneration of directors, key managerial personnel. In case of a private company, aggregate amount of remuneration drawn by the directors. So some financial information, some non-financial information is mentioned in the annual return. In case a penalty or a punishment is imposed on the company, directors, officers, then details of and the details of compoundable offenses, appeals, matters relating to certification, compliances, disclosure. So these are the things which you should remember if a question is asked on the contents of annual return. So basically you are trying to inform the ROC that see during the year these were my shareholders, debenture holders, other security holders, these were the dates when I conducted the meeting, so many members attended the meeting, was there any penalty imposed on the meeting, when was the what is the remuneration of the director. So that is information which you are giving to the ROC. Signing, yes, can be asked as a separate question. So you need to know the provisions of signing of the annual return. In case of one person company, small company, private company, if it is a startup, then it can be signed by the company secretary, or where there is no company secretary appointed, it will be signed by the director of the company. Company secretary is generally to be compulsorily appointed when the paid up capital is 10 crores or more. That time you need to appoint a whole-time company secretary. But here, if you're not eligible to appoint a company secretary, you can do so voluntarily. But if it is not, then a director can sign the annual return. In case of other companies, director and company secretary, and if suppose you're not meeting the criteria, you don't have a company secretary, then buy a company secretary in practice. So in this case, if you have a company secretary, director and company secretary, if you don't have appointed, if you have not appointed a company secretary, then director and company secretary in practice, okay, are you getting me? Then by a director and company secretary in practice, both will have to sign the annual return. Certification, yes, the limits are important for us. In case of a listed company, so listed company has to give a certificate of annual return. Or if you are a company having paid up capital of 10 crore or more, or maybe turnover of 50 crore or more, then the annual return is to be certified by a company secretary in practice. What will he mention in the certificate? He will certify that all the requirements have been properly filled and information which is given is correct, true, to the best of his knowledge. So he will just give a declaration that whatever are the compliances for the annual return that have been properly complied with, the information given is true and accurate to the best of his knowledge. So that certificate will be filed with ROC. So what will the company do? The company will file the annual return as well as the certification. Then we have inspection. Along with the register, we will maintain index of register. We will maintain other registers. We will maintain books. So who can inspect register, indices, annual return? Now, what are indices? It is a plural of index. Now, why is an index maintained? Like in your textbook, you have an index so that you can find the chapter easily. Similarly, index is maintained so that you can find the details of the members conveniently. Who can inspect? Now, see, the inspection can take place only during business hours, which is generally 9 to 6. Without the payment of fees, it can be inspected by members, debenture holders, other security holders, beneficial owners. On payment of fees, it can be inspected by any person other than these. These persons can take extracts of the books in registers and indices. If they want a copy, if you want a photocopy, then you will have to pay for it. Notice, all right. I want to call a meeting. So law says that you need to give a notice of the meeting. In the notice, we will specify the resolutions that the company is going to pass, along with other small details like when is the meeting, what time is the meeting, where is the meeting, how to reach the place of destination, what are the contents of the meeting, what are we going to discuss in the meeting, the resolutions to be passed, and also the explanatory statement will be provided for special businesses. So that the members, they read the resolution, they come prepared whether they want to vote in favor or against the resolution. Now, let's say if I want to appoint Mr. Iyer as a director, so many people will be curious to know who is Mr. Iyer, what are the different companies in which he is a director, what is the remuneration that you're going to give him, is he suitable for our company, what is his work experience, which are the other companies in which he's a director. So I would like to know everything about that person. If all this is discussed in the meeting itself, it will be so time consuming. So law says it is better that you give them an explanatory statement, and that will be sent along with a notice. In that explanatory statement, you will provide all the relevant details which are necessary for them to come to one conclusion whether they want to vote in favor or against that resolution. So notice will be served to every member. It will be given to equity as well as preference shareholders. Preference shareholders are entitled to receive the meeting. They can even attend the meeting, but they can vote only on resolutions which concern them as preference shareholders. They cannot vote on every resolution unless, of course, the dividend has not been paid for 2 or more years. It will be given to every director, auditor of the company, legal representative of the deceased, assignee of insolvent member. They will attend the meeting, but they will vote only in the capacity of either a legal representative or an assignee. For when should you give the notice? Notice should be given at least 21 days before the meeting. We want people who stay in faraway places to make arrangements to come at the place of the meeting. So law says you should give them at least 21, but clear days. Clear means complete days, full and complete days. Okay, so we should give them full complete days for making arrangements to come to the place of the meeting. We should, for calculating 21 days, exclude something. I'll explain first the example and then I'll read the theory with you. So we need to give them 21 clear days of notice. So if I want to give them 21 clear days of notice, how many days before the meeting should I dispatch my notice? If I want 21 clear days, so I will write 21 days. Okay. Then if I'm sending it by post, I will also have to consider 2 days of posting. Okay, I will consider 2 days of posting. Then the day on which the meeting is held, so date of meeting, that will be excluded. Why? Because that is not a full day. Okay, that you can't tell that I'm including the date of the meeting also. No, that will be excluded. Plus the date on which the notice is, date of service of notice. Date on which notice is served. Like you received the notice at 3 p.m. because your postman comes at 3 o'clock. So that day we will not consider, half a day is gone. So if I consider all this, one day, I need to dispatch the notice at least 25 days before the meeting. Okay. Only when it is dispatched 25 days before the meeting, I will get 21 clear days of notice for the members. So you need to ensure that the notice is dispatched at least 25 days before the meeting. So we will exclude the date on which the notice is served. We will exclude the date of the meeting, and we will include 2 days of posting. So considering all this, we will have to send the notice at least 21 days, 25 days before the meeting. Okay. What if I want to send a shorter notice? I want to call a meeting by giving a shorter notice. Like take the example of a Section 8 company. They have a privilege. They can send only 14 days notice instead of 21 days notice, but not other companies. They don't have that privilege. But law says that sometimes it is not possible for you to send 21 days of notice. So under certain circumstances you can, but we don't want to encourage this. Why? Because otherwise the companies, what they will do, they don't want members to come. They want limited people to attend the meeting. They don't want many people to come and attend the meeting. So they will send only 7 days of notice. They will send the notice 7 days before the meeting. They know that in such short span of time, not everyone will be able to make arrangements to come to the place of the meeting. So meeting will be conducted with just a few members. We can easily influence them. Law says you are acting smart. You want limited people to attend the meeting. We will allow a shorter notice only when, if it is an AGM and you have the consent of at least 95% of the members entitled to vote in the meeting. So out of 100% members, if 95 who are voting at the meeting give their consent, only then we will allow shorter notice. Now it is not possible for me to obtain the consent of 95 members. There are going to be members who will oppose this. So it is good for us. We don't want to allow you to call a meeting by giving a shorter notice. So this is one very good way. In case of other general meeting like extraordinary general meeting, if the company is having share capital, then the members holding 95% of such part of capital of the company that gives them a right to vote, only then they can vote at the meeting. So if you have share capital, then members holding 95% of the share capital which gives them the right to vote, only they can vote at the, only then we will allow shorter notice. Members having if the company does not have share capital, okay, does not have share capital, then in that case, members holding 95% of the total voting power exercisable at the meeting, only if they give their consent, we will allow a shorter notice. Students, I can't do anything. You will have to memorize these provisions. 95% is constant, only wordings change. You can write 95% of the members holding the total voting power, only because there are no shares. So 95% of the total voting power, only then we can allow shorter notice. Then we have different kinds of meeting. You have annual general meeting, section 96, 97 and 99. Now you must be wondering, where is section 98? In case the EGM is called at the request of the tribunal, okay, so if the tribunal calls a meeting, then that is covered under section 98. Okay, so now we found section 98. Okay, as the name suggests, annual, it means this is the meeting which is held once in every calendar year. It is not financial year, it is calendar year. Calendar year means once between Jan to December. All right, what is discussed in the annual general meeting? Why do we call it? There are two businesses which we discuss in the annual general meeting. One is the ordinary business and other is special business. Ordinary business means a business which is discussed in every annual general meeting of the company, or you can also say that it is discussed in annual general meeting of any company. These are the businesses which are generally discussed in the annual general meeting. They are known as ordinary businesses. We will consider the financial statements, the board's report, auditor's report, appointment of directors, declaration of dividend. It is proposed by the board of directors in the board's report. It is declared by the members in the annual general meeting. Appointment of auditors and fixing their remuneration. This is ordinary business. It is not the business which is ordinary or special. It is the meeting which makes it ordinary or special. So if I am appointing an auditor, if I'm appointing a director in the annual general meeting, it's an ordinary business. But the same director, if appointed in any other meeting, that will become special business. Any business other than the ordinary is considered as special business. When should we hold the first annual general meeting? The first annual general meeting should be held within 9 months from the end of the financial year. So if my financial year ends on 31st of March, let's say 2020, then I must hold it within 9 months. That is 31st of December 2020. Now, in case your company is incorporated, let's say on 3rd August 2019, company is incorporated on 3rd August 2019, when will the financial year end? Financial year ends on 31st of March 2020. Law says that you need to hold the first annual general meeting within 9 months from the end of the financial year. So I need to hold the meeting before 31st of December 2020. All right. Now, in the year 2020, I have held the annual general meeting. Now, we had discussed the first sentence that meeting must be held once in every calendar year. So 2020 is covered. Okay, we have covered 2020. This calendar year is covered. But what about the calendar year 2019? Company was incorporated, na? But is it possible? Can I hold the annual general meeting in 2090? What will I discuss? The accounts are not yet finalized. So law says, let's drop this. If you hold the annual general meeting before 31st of December, then it is okay. If you don't hold if you don't hold any annual general meeting in the year of incorporation. What about subsequent annual general meeting? It will be held within 6 months from the end of the financial year. So if the financial year ends on 31st March 2020, then I must, let's take 2021 now. Then the meeting must be held within 6 months. It means the meeting must be held by 30th of September 2021. You should also ensure that the meeting is held in every calendar year, and the gap between two AGM should not be more than 15 months. These three are cumulative requirements, means all the three have to be complied with. What if the gap is going more than 15 months? Then you should hold the annual general meeting before that. Extension of 3 months may be granted by ROC for subsequent annual general meeting. So if I go to the ROC for genuine reason, he may extend 3 months, and then I can hold the meeting by 31st December 2021. No extension is given for first annual general meeting because they already have 9 months for holding the meeting. Okay, we already have an extended time limit. Where should you hold the annual general meeting? What is the date of holding the AGM? Every AGM should be called during business hours. So what is the time? It should be held between 9 to 6. This is the business hours. Yes. On which day? It should be held on a day that is not a national holiday. Now, national holiday will include 15th August, that is the Independence Day, 26th January, Republic Day, and 2nd October, Gandhi Jayanti. Apart from these 3 days, you can hold AGM on any day. You can even hold it on Sunday. Where will it be held? Either at the registered office of the company or some other place within the same city, town, village where the registered office is situated. Okay, you can hold the AGM in any place but within the same city, town, village in which the registered office is situated. Over here, you can write down that annual general meeting of AGM of an unlisted company can be held anywhere in India, provided the consent of the members is obtained either in writing or through electronic mode. Okay, provided that we obtain the consent of members either in writing or electronic mode in advance, and in that case you can hold it anywhere in India, but only for an unlisted company. Then we have the extraordinary general meeting. Now, I can't wait for the annual general meeting. No, meeting can be called any time during the year. I want to take decision, I need to call the meeting of members. Meeting which is called between two annual general meetings, you can call it any time, whenever you require. Meeting held between two annual general meeting is known as extraordinary general meeting. So this is a meeting which can be called at any time during the year. Any meeting called between two annual general meeting is known as extraordinary general meeting. Now, EGM may be called by the board of directors on their own. They want to take decision, you can call it anytime. Like you want to shift the registered office from one place to another, you need to pass a resolution, call a meeting anytime. It may also be called on the requisition. Requisition means request. It can be called on the requisition, that is request of members. Members want to remove the managing director. Members want to take some decision. Board is not calling the meeting on its own, so the members can send a request. Now, requisition means that you have to send a request. If one member sends request, the company is not going to call EGM. So we need the request from at least members holding 1/10 of the paid up capital, or if you don't have share capital, then at least 1/10 of the total voting power. Now, even in college, If only one student requests, the principal is not going to listen. But if many of them give a request in writing, then the principal will be forced to comply with your requirement. So you can request the company, and then the board of directors will call an extraordinary general meeting. But if the board fails, then requisitionists can themselves call a meeting, and when they conduct the meeting, whatever expenses they incur for the meeting, that they can claim reimbursement from the company, and the company will deduct that from the remuneration of directors. I like that point. If the directors are not calling the extraordinary general meeting on the request of members, members can themselves hold the meeting and recover the cost from the company. Company will deduct that from the remuneration of directors. It's a good point. The tribunal, yes, either on its own or on request of members, that see the company is not calling the meeting and we can't call it. So the tribunal will ask the company to call an extraordinary meeting, and in case the order is received by the tribunal, the company will have to call the meeting. What is the period of calling and holding the meeting? As soon as we receive the request, the notice from the requisitionist, the board will call a meeting by giving 21 days notice, and they will actually hold the meeting within 45 days of receiving notice from members. Okay. As soon as the company receives the notice from the requisitionist, within 21 days, they will call the board meeting, and they will hold the board meeting within 45 days. So within 21 days, you need to call, and within 45 days of the notice, you need to actually hold the meeting. In case they fail, then the requisitionist can call the meeting within 3 months from the depositing of requisition. See, even they have an option, no? To call, okay, arrow, yes, this way. Requisitionists can themselves call the meeting, but they can call it within 3 months from the date of deposit of the requisition. So as soon as the notice is given to the board, they should call it within 21 days and hold the meeting within 45 days. If they fail, then we give them another 45 days to the members to actually conduct the meeting. So 45 plus 45, 90 days, that is 3 months. I'm just giving you an approximate calculation. That much time is given for the requisitionist to hold. If they don't want to do it, they can go to the tribunal, and the tribunal will call an extraordinary general meeting. Whatever is the decision taken, it is done by voting. Now there are different methods of voting. I will not be able to discuss everything over here in detail. For details, you can refer my textbook. Now, voting by show of hands. There are different methods of voting. Voting by show of hand is the easiest one. So members will be assembled. The chairman will conduct the voting by show of hands. Members who want to vote in favor will raise their hand. Then the chairman, he will not go to count each and every members, but just by sight, he will see if majority of them are voting. Then in that case, yes, the voting will be considered as done. Chairman, his decision is final. If he says, I have conducted voting by show of hand, it is done. We are not going to ask him how many members voted in favor and how many voted against the resolution. But voting by show of hand is a very crude and it's a very basic method. It will be conducted unless the member asks for the voting to be conducted by poll. Unless we don't receive any particular request, generally the meetings conduct voting by show of hands. If the member requires, they can also get the voting conducted by poll. What happens in that? A polling paper is given to the members who are present in the meeting. They will write whether they want to vote in favor or against the resolution. A box will be kept. They will keep the polling paper in the box. A scrutinizer will open the box, count the votes, and decide whether the resolution is passed or not. He will maintain a report, and the papers will be kept with him. Once he's done with the counting, once the report is prepared, he will handle the polling papers to the company. But who has the time to go and attend the meeting personally? Then in that case, we have given them an option of electronic voting. In case of electronic voting, the notice will specify that we are giving you an option of electronic voting. Read the instructions in the notice itself. Log into the website URL is already given over there. Log in there with your DPID, client ID. A page will open. You have to just click whether you want to vote in favor or against the resolution. Your vote will be cast. This vote will be kept locked. There are so many people who don't know how to operate that electronic medium. For them, along with the notice, we will also send a postal ballot. Now, what is a postal ballot? They send you a paper. It's like an envelope on the back side. On the front side, they will give you the resolution to be passed. You just have to tick whether you want to vote in favor or against the resolution. Fold the envelope, put it in the post box. That is nothing, your postal ballot. It will be sent to the scrutinizer. Scrutinizer will open the papers, see whether you have voted in favor or against the resolution. He will count, and he will also unlock the votes that he has received through electronic mode. So both the votes will then be counted and you will decide whether the resolution has been passed or not. There are steps, there is a long procedure. In my notes you will find that all the steps are covered in 10 steps only. Everything is covered in 10 steps, whereas if you see the act, if you see the module, it's a very lengthy procedure, but I have given it in an answer form in my notes. For the notes you can purchase it from my website theorymasterslearning.com. Next, let us discuss something about minutes book. Now, what are minutes? Meeting is over. After a few days, will you remember what was discussed in the meeting? Nobody can remember exactly what was discussed in the meeting. That is why law requires to maintain a record of the proceedings of the meeting. That record is known as the minutes book. Minutes, because you are maintaining a record, okay, minute by minute. It's not that you write everything in the minutes book. It's just that during the period of the meeting, whatever was discussed, that will be properly drafted and a book will be prepared. We will write everything in a proper manner, and that is known as a minutes book. Loose sheets of paper do not constitute a book. It's not a book exactly. Like what I have seen is that everything is maintained in the soft copy on the computer. After let's say 6 months or a year, we take a printout and we properly bind it. So I have seen books which are bound and they contain all the minutes. Most of them are in the soft copy, and yes, you can also get a printout and then bind it into a book and then maintain the record for the entire year. But it doesn't happen that you maintain a book for every meeting. All right. So minutes book section 118 is nothing but a record of the transactions of whatever was discussed in the meeting, the resolutions passed in the meeting. This can be used for future reference. It can be used as an evidence in the court of law, proving that XYZ resolutions were passed in the meeting. The minutes book, they will contain proceedings of the meeting and will be kept within 30 days from the conclusion of every such meeting concerned or passing of resolution by postal ballot in the books. So as soon as the meeting is conducted, resolutions are passed, then after 30 days, within 30 days, you need to properly prepare the minute. That is generally done by the company secretary. He is also a part of the meeting, and he makes a note in the meeting of whatever was going in the meeting. Then after that, he will sit properly, draft the minutes, get it signed by the chairman of the meeting, and then file the document in the minutes book. The minutes book shall be consecutively numbered. It means all the pages shall be serially numbered. Minutes of each meeting. Now each meeting means that you need to prepare minutes of every meeting, like the board meeting, committee meeting, then you have annual general meeting, extraordinary meeting, class meeting. Minutes will be prepared for every meeting, containing fair and correct summary, okay, containing fair and correct summary of the proceedings that took place at the concerned meeting. Correct and fair, it means that whatever important was discussed in the meeting, everything is maintained in the minutes book. All the appointments made, like you are appointing the director, the auditor, shall be included in the minutes of the meeting. So resolutions which are passed for appointment will be included. This is very important for exam. Other points were like fairly important, but this is very important for exam. Minutes shall be signed by the board of directors. Will sign the minutes for the board meeting, for the meeting, board meeting. Okay, just changing the pen color. For the board meeting or committee meeting, it will be signed by the chairman of the same or next succeeding meeting. Now, why are we allowing the chairman of the next succeeding meeting to sign it? See, in case of a board meeting, chairman will sign. Now, who is a chairman? Now, chairman or chairperson, you can say that also. Chairperson is a person who presides over the meeting. Okay, he is very different from the chairman of the company. Chairman of the company is someone who is the senior most, not by age, but someone who owns a lot of shares of the company. So chairman of the meeting is different from chairman of the company. Your chairman of the company is someone who presides over the meeting. He ensures that the decorum of the meeting is maintained. So chairman, he will sign the minutes, and if the chairman is not available, maybe he died or maybe he's out of India, currently he's not available, then chairman of the next succeeding meeting can sign, because board meeting needs to be held once in every 3 months, once in every quarter. So if the minutes could not be signed in this meeting, it can be signed by the chairman of the next meeting, because anyways we are going to meet. But what if you have conducted a general meeting, like an extraordinary general meeting or an annual general meeting? Now extraordinary general meeting is conducted as and when required. You don't know when you are going to meet for the next extraordinary meeting. Annual general meeting is held just once in a year. Now you cannot wait for a year, or you cannot wait for the next meeting for the minutes to be signed. In that case, chairman of the same meeting will sign preferably within 30 days of meeting, or if the chairman is unavailable due to any reason like death, or maybe he's away, he's not in India, it may be signed by a director duly authorized by the board, because we cannot wait for the next annual general meeting. We cannot wait for the next extraordinary meeting, because we don't know when the next EGM will be held. Students, this is important for exam, because case-based questions can be asked on this. If a theory question is asked on the minutes, then you can write the entire part that you see on the screen, but mostly questions, case-based questions are asked on this. Minutes will be kept in accordance with the provisions. They will serve as an evidence in the court in the proceedings therein. All right. Now, this is also important because, again, case-based questions are asked on this part. So, two things important from the minutes part. Any of the following matters shall not be included. Okay, I'm highlighting the word not. It will not be included in the minutes if, in which the opinion of the chairman. Now, what is the story behind this? We discussed that minutes book should contain true and fair summary. It should, see, I have written over here, it should contain fair and correct summary, true summary of whatever what was transacted in the meeting. Now, we had called a meeting to remove the managing director of the company. In that case, you need not specify the various reasons or the dialogues that were taken. Let's say he was accused of inappropriate behavior with a female employee. Now, you need not write what discussions took place in the meeting. You need not write the exact dialogues that were shared in the meeting. But the shareholders insisted that no, everything that was discussed in the meeting should be mentioned there, because it should contain true and correct summary, fair summary of whatever was discussed in the meeting. Sorry. But the chairman will have absolute discretion in whatever is to be written in the minutes book. Chairman will decide what should be included and what should not be included in the minutes, and his decision will be final. So if the chairman feels that it may be defamatory of any person, defamatory means it affects the goodwill, the reputation of the person against whom that statement is made. If he feels that no, it's quite derogatory, it is unfair on that person's goodwill or personality, then if he considers it as defamatory, he may disallow the information from being published. It is irrelevant, it is immaterial to the proceeding. He says that we need not write all this, just write the important parts. It is detrimental to the interest of the company. Sometimes the board of directors, they had a very heated argument. There was a lot of disagreement. There was a lot of negativity in the board meeting. You need not write that. What will the others who refer that minute saying that the board of directors, they're not agreeing on a thing, and is this what they actually discussed in the meeting? It will be detrimental to the interest of the company. Sometimes in the board of the company, there are two groups and there is a lot of media attention also. We don't want that anything should harm the interest or the image of the company. So the chairman may disallow all that from being written in the minutes. The matter to be included or excluded, this is very important, so I'm highlighting that in red. The matters to be included or excluded shall be at the absolute discretion of the chairman of the meeting. Members cannot insist that the following matter should be included in the minutes. Whatever should be included or excluded depends on the chairman. All right, students. So this is an important part for exam. Generally, a case-based question is asked, but in that you will have to write the entire theory points, which you can see on the screen. Okay, so proxy section 105, yes, can be asked as a theory or a case-based question. Now, who is a proxy? It has the same meaning which you know in college. You are not attending the lecture, so you ask your friend to attend. That person who's attending the lecture for you is your proxy. So proxy means member is not able to attend the meeting. So member authorizes a person to attend the meeting. Now, how will the company know who is authorized? So the company sends a form or a proxy form, which the member will fill, submit it to the company, informing the company the person who is going to come and attend the meeting. The form as well as the person is known as proxy. So let us go through the provisions of proxy. Proxy is an instrument. It should be in writing, because you cannot orally inform the company who is going to come and attend your meeting. So proxy is an instrument in writing. It has to be in writing. So this is the first requirement. Appointing another person, whether he is a member or not, doesn't matter. You can send any person as your proxy to attend the meeting and to vote at the meeting. He may or may not be a member, to attend and vote at the meeting on behalf of the member who is appointing him. So you can appoint someone else in your position, and that person will go and vote at the meeting. The instrument as well as the person is called proxy. So instrument as well as that person is called proxy. Proxy will be launched with the company at least 48 hours before the meeting. So law says that inform us. The company says inform us who's going to come and attend the meeting, and that information should be given at least 48 hours before the meeting. You can give a shorter notice. Your articles can allow a shorter notice. Even if you give us, let's say, 12 hours notice, 24 hours notice, we are fine with it. You cannot ask for a longer period. You cannot say, no, you have to give at least 72 hours notice. That is not allowed. So 48 hours before the meeting, that is allowed. Proxy may be inspected. Now, there are certain people who want to know who all are attending the meeting, how many proxies lodged. We want to see. So people can inspect by giving notice at least 3 days before the meeting, but the actual inspection can start only 24 hours before the meeting, and it can conclude till the end of the meeting. Actual inspection can start only 24 hours the meeting, and it can continue till the end of the meeting. A person may hold maximum 50 proxies. Now let's say that I am holding the proxy of Mr. X. I'm also holding the proxy of Mr. Y. I'm also holding the proxy of Mr. Z. Like this, I can hold proxy of 50 persons, but there are certain restrictions. If you are holding proxy of 50 persons, then their share in the capital should be less than 10%. Ma'am, we were holding proxy of 20 people, and when we added their share in the capital, it is exceeding 10%. Then you can hold only 20 proxies. So you can hold maximum 50 proxies, provided when you add their share in the share capital, it does not exceed 10%. But what if we are holding proxy of just one person and his share in the company is more than 10%? Then you cannot hold the proxy of any other person. So let's say we are holding the proxy of Mr. A, and his share in the company is, let's say, 12%. Then we can hold his proxy even though it is exceeding 10%, but we will not hold proxy of any other person. Suppose the member and proxy, they both attend the meeting. It is possible, no? We both attend the meeting. Then members' vote will be counted. Member will be allowed to vote. Proxy will be automatically revoked. Okay, proxy will be automatically revoked. Proxy appointed later in time shall prevail. Now, let's say that I appointed you as a proxy, but then you told me that, no, ma'am, I'm very busy, I can't attend. Then I appointed someone else as my proxy, and I submitted his form also. But both attended the meeting, then the one who was appointed later in time will prevail. But even in that case, you should ensure that it reaches at least 3 days before the meeting. It reaches at least 48 hours before the meeting. So that criteria should also be considered, that your proxy should be lodged at least 48 hours before the meeting. The one which is appointed later in time will prevail. So these are the conditions for proxy. In case a question is asked, you have to write all this in your answer. Then one very interesting concept of quorum. Quorum, section 103, it refers to the minimum number of members required to be present to constitute a valid meeting. Let's say, for example, I have 3,000 members in my company and only 2 attend the meeting. They vote for all the 3,000 members. They take decision for all the 3,000 members. How can we allow only 2 persons to take decision for the majority? So law requires minimum number of members to be present in the meeting for a valid meeting, for conducting a valid meeting. And that minimum number which has to be present in person is known as quorum. So quorum refers to the minimum number of members required to be present to constitute a valid meeting. If this minimum number is not present, then meeting will be adjourned, it will be postponed. What if in the adjourned meeting also quorum is not present? Then adjourned meeting cannot be further adjourned. The number of members who are present in the adjourned meeting will be considered as quorum, and the meeting will be conducted. Resolutions will be passed. Resolutions are also valid. Quorum must be present throughout the meeting. It should not be, I will mention it over here, it must be present throughout the meeting. It should not be that quorum was present when the meeting started, then everybody left and only 2 members or maybe a single member was taking decision and passing resolutions. That is not possible. quorum must be present. Now, quorum refers to the minimum number of members mentioned in the act or articles, whichever is higher. We want that maximum people should be present in the meeting and they should take decisions for the company. We want maximum of them to participate. So it is the number mentioned in the act or articles, whichever is higher. If you are a public company, then in case of public company, if members are 1,000 or less, then 5 members should be personally present to constitute quorum. The number is not very high. If there are 1,000 up to 5,000, then 15 members to be personally present. If there are more than 5,000, then 30 members to be personally present. Now, because there is electronic voting option available, so the quorum for personal present, that is not very high. So it is possible for 5, 15 and 30 people to be present considering the number of members. If you are a private company, then the number mentioned in the articles or 2 members personally present, whichever is higher. All right. If the AGM is called on the requisition of tribunal, so if the tribunal has called for the AGM, why? Because the company was not calling an AGM. So the tribunal has ordered for calling the AGM. Then even one member personally present is quorum. So in this case, the quorum is not relevant. Even if one member is present, that is quorum. That person may be present either in person or proxy. All right. In case of extraordinary general meeting called on the requisition, that is request of members, absence of quorum will dissolve the meeting. This we had studied earlier also. You call the meeting and you don't come to attend the meeting. If it is a meeting called on the requisition, request of members, and the quorum is not present, it will be dissolved. We will not adjourn it. But what if the board of directors have called an EGM and the quorum is not present? Then it will be adjourned. Okay, so board has called either on its own or request of members. If the board is calling on its own and the members are not present, then in that case it will be adjourned. But if the board is calling the meeting on the request of members and the members are not coming, then the meeting will be dissolved. Quorum must be personally present. A person representing 2 members shall be counted twice for quorum. So let's say, for example, that there is a Mr. X. He is attending the meeting on behalf of company A as well as company B. Now, company is an artificial person. Company cannot attend the meeting. Company cannot vote at the meeting. So they send representatives. Now, company A has represented Mr. X to attend the meeting and company B has also sent Mr. X to attend the meeting. Now, X is attending the meeting, once on behalf of A, another on behalf of company B. He shall be counted twice in quorum, one for company A and other for company B. In case the number of members falls below quorum, then all the members must be personally present to constitute quorum. Let's say, for example, that the quorum of my company, as per the articles, was 12 members personally present. Now, members left, and I have in my company only 8 members left. Okay, I have a company in which there are only 8 members remaining now. So law says that when all these 8 members are personally present, see, it is below quorum, we agree, but if all are personally present, then it is considered as valid quorum. Then you'll have to alter the articles to change the number of quorum, but then suddenly if the number reduces, so then in that case, when all are personally present, that will be considered as quorum. So students, these were the provisions relating to quorum. Now, what kind of questions can be asked? There is one question which I remember, that when is quorum immaterial? When is quorum not required? So you can say quorum is not required when the tribunal, okay, has called for the AGM. But what the institute is expecting, that when the number falls below quorum, then it is irrelevant. All the members personally present will constitute quorum. All right. So there are many questions. For more questions, you can refer the CA Inter-Law compiler. I'm leaving a link in the description box. It has all the past exam questions, study material, RTP, MTP questions arranged unit wise. So do go and check out the law compiler. I'm sure it will help you a lot, because you will know what to write in the answer, how to write, how to start the answer, what is the content expected by ICI, and all the questions are arranged unit wise. So students, with this, I think we also we have completed the chapter on what should I say? Yes, management and administration. Next, let us discuss declaration and payment of dividend. Next, let us discuss declaration and payment of dividend. Yes, it is important for exam, and in fact, students, all the sections are important. You will say, ma'am, everything in your chart book turns out to be important. Students, the chart book is made in a manner that all the important concepts are covered here. Now, the best part of the chart book is that everything is given section wise. All the important points are covered. So it will be very easy for us to finish this chapter in just 2 pages. Now, what kind of questions can be asked? They can ask you theory, even case-based questions on from this chapter. Now, declaration on payment of dividend, all sections are important because it's a very small chapter, and at some or the other point they may have asked a question on any of these sections. So I feel that you should remember the section numbers. That is why I have specifically given you a list of section numbers. Okay, so section 123, it covers declaration of dividend. 124, unpaid dividend account. 125, investor education and protection fund. 126 is right to dividend. Yes, this is one section on which questions have not been asked. 127, punishment for failure to distribute dividend. Now, under 123, we will find what are the sources of dividend, what can be used to pay dividend. 124 says that in case the dividend is declared but it is not paid, then it should be transferred to a separate bank account known as the unpaid dividend account. Investor education and protection fund, as the name suggests, this is the fund which is created for protection and education of investors. There are certain specific credits and specific utilization of this fund, so we will be studying that. Section 127 talks about failure to distribute dividends. So what is the punishment, what is the penalty imposed in case the dividend is declared but you have not paid? So penalty for the company as well as the officers and directors. Let us discuss declaration of dividend, but before that we should understand what is the meaning of dividend, why is a dividend declared. Now, the shareholders, they are members in that case, they provide finance to the company, they give capital to the company, so they want something in return, and what they get in return is dividend. Now, the company says that we have earned profit because of your money, so we would like to share some percentage of profit with you. That distribution of profit is known as dividend. Only companies can declare dividend, not a proprietor or a partnership firm. So sharing of the company's profits distributed among the members is known as dividend. It is a return on capital for shareholders. See, you have invested money. Yes, you do get some growth if you can sell the shares further. But if you get something extra, from the company, they give you something extra. Like we have earned and we would like to give you also something. That extra is always appreciated. Equity dividend, it depends on, yes, you should remember this. Equity dividend depends on the dividend policy of the company and the availability of profits after satisfying the rights of the preference shareholders. See, preference shareholders, they have a right of preference. They will get dividend, they will get repayment of capital even before it is paid to the equity shareholders. So out of the profits, we will first pay the preference shareholders, and then whatever is left, that will be given to the equity shareholders. So how much dividend will I get in a particular year? That depends upon, one, the dividend policy of the company, and two, it depends on the availability of profits, whether I have profits to distribute dividend or not. The dividend is generally declared by the shareholders in the annual general meeting, but it is recommended by the board of directors through the board's report. Dividend is defined superbly. You will not understand what is the meaning of dividend. It simply says that dividend includes interim dividend. Now, this is the definition of dividend. They have not mentioned whether it is distribution of profit, what is the meaning of dividend. They just say that dividend includes interim dividend. So from this, we can conclude that the provisions applicable to dividend apply to interim dividend also. Now, what is the meaning of interim dividend? Interim means it is paid between two annual general meetings. So here I have for you separate. Yes, where is it? Yes. We have a classification of dividend on the types of dividend. It may be classified on the basis of time or the nature of shares. On the basis of time, it may be final dividend or interim dividend. Interim dividend means a dividend which is paid between two annual general meetings. It is paid during the year. It is something extra which is paid. It is not an obligation of the company. It is just paid extra from the board of directors. It is recommended as well as declared by the board of directors. Whereas final dividend is recommended by the board and it is mentioned in the director's report. It is declared by the shareholders in the annual general meeting by just passing an ordinary resolution. This is an ordinary business. it is a business which is carried out, or it is some activity which is carried out in every annual general meeting of any company. So interim dividend is declared between two annual general meetings, and it is declared by the board, recommended as well as declared by the board. Final dividend is recommended by the board, declared by the shareholders in the annual general meeting. On the nature of shares, it may be either preference dividend or equity dividend. Preference may be cumulative or non-cumulative. See, the charts are self-explanatory, students. So cumulative means that if the dividend is not paid in a particular year, it will have to be paid along with the dividend of the next year. It will accumulate. Before the dividend is paid to the equity shareholders, we will first clear off whatever is the accumulated unpaid dividend of the preference shareholders, and then we will pay the dividend to equity shareholders. What are non-cumulative preferences? Non-cumulative means that if the dividend is not paid in a particular year, that will lapse. Equity dividend depends on the dividend policy of the company and the availability of profit. Now, what if the board of directors have recommended 10% rate of dividend? The members cannot say 10% is too less. We need at least 15-20%. No, you cannot give more than what is recommended by the board of directors. Yes, you can give less. Now, if there is no profit, okay, if there is no profit, can we give dividend? Law says yes, you can give dividend, but members may decide that since there is no profit, we don't want dividend. Even the board has recommended, we don't want. Sometimes interim dividend is given even if there is no profit, just to maintain the goodwill of the company. Okay, now I want to give dividend. So what are the sources of dividend? From where will I arrange for money? Law says that you can give the dividend out of current year's profit. Anyways, you are earning profit for distribution only. Give some portion in the form of dividend. There are no restrictions in case the dividend is paid out of the profits of the current year. You can also utilize profits of any previous financial year after providing for depreciation. Suppose the profits of the current year are insufficient, but still you would like to maintain the rate of dividend that you have been giving throughout these years. So you can utilize the past profitability of the company. So out of the profits of the previous financial year, after providing for depreciation means you have to make provision for depreciation, and only after that whatever is remaining, that can be distributed in the form of dividend. Money provided by the central or state government in pursuance of any guarantee given by that government. So sometimes the company is not in a position to pay dividend, but we don't want the market sentiment to become negative. So we that is, the government will say that okay, I will give you some money, you give that in the form of dividend, so that there is confidence maintained in that particular type of industry or company. So money given by central government. Let's go through it once again. We will use the current year's profit. Then we will use the profits of the previous year. You can use the profits lying in the P&L account or the reserves, general reserves, free reserves, which are used for distribution in the form of dividend. You can also give money provided by the central or the state government. Now, before you pay dividend, there is an option, a suggestion given to the companies. Why don't you transfer some money to the reserve? Like for example, take your example, only personal example. You have earned 10,000 rupees during Diwali. You went to various, you went to your sister's place, brother's place, or you went to your relative's place. They gave you some money. Your dad gave you some money during Diwali. So you have now a small fund of 10,000 rupees. Your mom will come and tell you, beta, don't spend the entire money. Keep something and spend only, let's say, 2 or 3,000. No, keep something for the rainy day. You can buy something, learn to save. Similarly, we are also advising the company. We are advising. It's not compulsion. We are just advising the company. Don't spend whatever profit you have earned in this year. Why don't you transfer some profit in the reserves? You can't force. See, your parents also cannot force you. If you tell them, no, I want to spend, very rarely I get this amount of money, I want to go and buy a mobile, or I want to spend on clothes, or whatever it is. So they can't force you, no. Similarly, here also we can't force the company that you have to transfer. So we just give a suggestion that before declaration of dividend, transfer such percentage of profit as you may consider appropriate. This is left at the discretion of the company. What if they decide they don't want to transfer? It's their will. What if they decide if they want to transfer 20%? That's absolutely your discretion. Whatever is remaining after that, it can be used for declaration of dividend. This is important for case-based questions, students. This is important for case-based questions. Once the dividend is declared, it has to be deposited in a separate bank account. So within 5 days, we will deposit that money in a separate bank account. We will not leave it with the company. What if the company spends that money? So the amount of dividend, including interim dividend, shall be deposited in a scheduled bank in a separate bank account within 5 days from the date of declaration of dividend. The points which I have highlighted are the keywords. You should mention all this in your answer. So the amount of dividend, including interim dividend, it means the rules apply to interim dividend also. They shall be deposited in a scheduled bank, okay, in a scheduled bank, in a separate bank account within 5 days from declaration of dividend. So if the dividend is declared within 5 days, you have to deposit the money in a separate bank account, and it has to be paid within 30 days of declaration. It is an obligation of the company. If you have declared the dividend, you will have to pay it. It's an obligation of the company. It's like a compulsion. You have to pay it once declared. Now that we want to pay dividend, what are the different ways in which we can pay dividend? Dividend can be paid either in cash, and if you want to pay it in cash, not in kind, dividend cannot be paid in kind, not in kind. Now you are a company manufacturing toys. You can't tell the members that I don't have money to give. Why don't you accept toys? You can't give it in kind, but yes, you can give it in cash. And if you are giving it in cash, there are different ways in which you can give. You can give cash, but you can also, okay, you can also give it by check, dividend warrant, or any other electronic mode. So we can give it check, we can send it to the registered address of the members, or you can give them a dividend warrant which they will go submit it to the bank, and they can get dividend. Okay, bank will pay them dividend. You can also submit it any electronic mode. Now electronic mode means that it will be directly credited as NEFT in your bank account. That is what normally happens. Like even I get dividends in my registered bank account. So I can invest only through that account. I will get the sales proceeds also in that account. My dividends are also deposited in that account. It is payable to the registered shareholder of the company. Okay, it is payable to the registered shareholder. Registered shareholder means person whose name appears in the register of members. So if your name is mentioned in the register of members, you will get dividend. If your name is not in the register, you will not get dividend. So you have to ensure that on the book closure date, okay, on the record date, that your name is entered in the register. Normally it is done by the depository, but if you want dividend, you should buy it before that record date. It can be given to his order, means authorized person or a banker. Now it may happen that X may direct the company to pay the dividend to Y. He is the owner of shares, but he's saying that the dividend should be paid to Y. So Y is the beneficial owner of shares. Beneficial owner means he will get the dividend. We'll have to inform the company that instead of me, you pay the dividend to this person. It can also be paid to the banker. Now, this is important, students. It is important for theory question. A case-based question will be asked on this, but your expectation is to write theory only. Okay, you have to write the theory. I have simplified the provisions for you. So let's go through it. Rules to be followed by declaring dividend out of reserves. Please note that these rules are to be followed only in case the dividend is declared out of reserves. These rules are not to be followed in case we are declaring dividend from the current profits of the company or past profits which are credited in the profit and loss account. So this is not to be followed if you are using the current year's profit. It is not to be followed in case you are using the profit and loss account. You will follow these rules only when you maintain reserves. Okay, if you're using reserves. Now, what is the difference between profit and loss account and reserve? I'll give you my personal example. Whenever I go for lectures, I always have a bag in which I have my laptop, I have the iPad, or there are other things, and my wallet is separate. Now sometimes it happens that my wallet is I remove it and I go out on the days that I'm not giving lectures. So there is always a fear in my mind that if my wallet is with me on non-working days, and what if I forget to take it with me on working days, I reach the station or I reach the car parking and I want to pay the parking charges, I will not have money. I always fear that I will forget my wallet at home, or I will not check it before leaving whether I have kept it in my bag or not. So what I do is, in my bag at various places, I keep loose change. Like I keep 500 rupees or 100 rupees just lying in my bag, which I normally carry to class. So in case I forget my wallet, I know that I have something in reserve. If I need to pay someone, I will have. Then now you may say, ma'am, you can always use Paytm, but it's not always the case. No, not everyone is still using Paytm or other electronic means. What if I need cash only? So for that, I always keep money here and there in my bag. So that, in case of emergency or in case I'm not carrying my wallet, I can use that money. That money which I keep in my bag separately is my reserve. Okay. And another case, like your parents gave you 10,000 rupees during Diwali. You take 2,000 rupees, keep it in your wallet. Yes, that is for spending. Remaining, you keep it, somewhere behind so that, you don't spend it, or you want to spend it on a particular day. Whatever you have kept aside, that is your reserve. Whatever you have kept in your wallet for spending, that is your P&L. Similarly, the company can spend the current profits. The company has kept money in the profit and loss account. This is like your wallet. It is for spending. But whatever they keep in reserve, it is for a specific purpose, or it is generally for the growth and development of the company. It is something for rainy days. It is something when the company is in really need of money, when I don't have profits. So law says that when you use your P&L, it is generally for spending only. But when you use your reserves, then we need to keep a check on you. Then we need to impose rules. Then we need to impose limitations. So these rules will apply only when the dividend is declared out of reserve. Now, this is the rule number 1. Whatever dividend you declared, the rate of dividend should be less than or equal to average rate of dividend during the last 3 years. Okay, so whatever dividend I'm declaring in this year, that rate of dividend should be less than the average rate of dividend for the past 3 years. So what I will do is that I will calculate the dividend. I will find out the dividend rate of the first year, second year, third year, and then calculate an average. Whatever dividend I declared in the current year, the rate should be less than this. All right. Next is that if I have not declared dividend in any of these 3 years, then this provision will not apply. But if I have declared dividend in 2 years, not in 1 year, then this average can be calculated. But if I have not declared dividend in any of these 3 years, then this provision, then this rule will not apply, obviously. Then the second rule is that whatever amount you withdraw should be less than 10% of the paid up share capital and reserves as per the latest audited financial statement. So if 100 rupees is lying in my reserve, okay, this is my reserve. Whatever I withdraw should be less than, okay, whatever I withdraw should be less than 10% of the paid up share capital plus free reserve. Okay, whatever I withdraw should be less than 10% of the paid up capital. So there is a limit on how much I can withdraw. Otherwise, if there is no limit, the company will keep using that reserve, and one fine day they will not have anything for emergency. The third rule is that the amount, whatever you are withdrawing, should first be used to set off the losses in which the incurred in the financial year in which the dividend is declared. You also have to make provision for depreciation. Okay. So whatever you withdraw, that should be first utilized to set off the losses incurred in the financial year. Now, this is what happens, no? If suddenly you get money one fine day, logic says that you have to pay your debts. Like you had taken loan of 500 rupees from your friend. So this time during Diwali, you got 10,000 rupees. So that 500 rupees is first to be utilized to pay your friend, and then only you can spend it, no? So whatever losses are incurred in the previous year, you will first set off that losses, and then whatever is left, that will be used for declaring dividend. The fourth rule is that whatever balance is remaining, okay, whatever balance is remaining should be at least, it means it should be more than 15% of the paid up share capital plus reserves. Okay, so whatever is remaining, on that also we require that you should at any point of time maintain at least 15%. But what if after withdrawing my balance is reducing, it is less than 15%? Then law says that don't use 10%. No, don't withdraw 10%. It should be less than 10%. So you withdraw only 6 to 7%. Ensure that after withdrawing, you have at least 15% of the paid up capital and reserves remaining in that fund, in that reserve. So these are the 4 rules that you need to follow. The first rule is that the rate of dividend should be less than the average of the last 3 years. The second rule says that whatever you withdraw should be less than 10%. The third rule says that whatever is withdrawn, that should be first used to set off your losses of the previous year. And the fourth rule says that whatever balance is remaining should be at least 15% of the paid up capital and reserves. Can be asked as a case-based question. Next, we have prohibition on payment of dividend. Now, in case the company has prohibited in the payment of deposits, that is public deposits, then we will not allow the company to pay dividend unless and until they comply with their current obligation. So company cannot declare dividend if it defaults to comply with the provisions of section 73, which is prohibition on the acceptance of deposits, and section 74, which asks for repayment of deposits before the commencement of the Companies Act. So now only eligible companies can accept deposits from the public, and in case you have accepted deposits, then you will have to repay them. Deposits which were accepted earlier before the commencement of the Companies Act 2013, they will have to be repaid. If you fail to do so, we will not allow you to declare dividend. The logic behind this is that you don't have money to pay deposits and you want to declare dividend. First, you utilize that money for the payment of deposits, and then we will allow you to declare dividend. So can be asked as a case-based question where they will ask you, well, they will mention that the company has defaulted in paying the public deposits. It wants to declare dividend. Can it do so? Your answer will be no. Then we have the unpaid dividend account, section 124. The company has declared dividend. Within 5 days, we discussed earlier, it has to deposit that money in a separate bank account. They have to pay that dividend within 30 days of declaration. So I have made a small timeline for you students. This is a timeline which you will follow to frame the answer in case it is asked on unpaid dividend account. You can easily convert each and every point of this into a sentence. The company should, within 30 days from the declaration of dividend, pay the dividend. If it fails to do so, if the dividend is not paid, or when we have given the warrants but it has not been claimed, then the company shall, within the next 7 days, deposit that amount in the unpaid, unclaimed dividend account opened with a scheduled bank, which is called the unpaid dividend account. So in case you have not paid the dividend, or maybe you have paid but it has not been claimed by the shareholder, sometimes if the dividend amount is very less, they don't go with dividend warrants to the bank. So if the amount is unclaimed, then within the next 7 days, you have to transfer that unpaid or unclaimed dividend account to a separate account maintained with a scheduled bank known as the unpaid dividend account. If you don't transfer within the 7 days, then you will have to transfer it along with interest at the rate of 12% per annum, calculated from the date of default. From the date of default till the date of deposit, we will calculate interest, and you will have to deposit that amount along with interest at the rate of 12% per annum. Then within 90 days of this transfer, you should prepare a statement mentioning the name, last known address, and the unpaid dividend amount, and you will have to place it on the website of the company or any other website approved by the government for this purpose. Now, it sometimes happens that we have sent the dividend warrants, but the other person says that I have not received it. Why? Because the address was changed. He has shifted from one place. He has forgotten to update the company, and or maybe due to any reason it is lost by the post. So he is complaining that he has not received the dividend warrant. Then in that case, for such people, or sometimes they give incorrect account number. So everybody knows that the company has declared dividend. If you have not received it, then you can inform the company if you can see it on the website. So it is just an intimation from the company to the member that, see, we have declared dividend and these are the persons who have not received dividend due to whatever reason. If you want, you can claim it from the company. So that is the whole purpose of placing it on the website, so that the other person, the shareholder, is aware that the dividend was declared but he has not paid it. So he has to check what is the reason that dividend was not credited in his account. Then maybe his account number was incorrect, or he has not updated his residential change of address with the company. So to enable that, we ask the company to upload the statement within 90 days on the website of the company, as well as the website approved by the government for this purpose. Now, this amount will remain in the unpaid dividend account for a period of 7 years. If the amount is not claimed, then after 7 years, the amount will be transferred to IEPF, that is Investor Education and Protection Fund. What will be transferred? The unpaid dividend amount as well as the interest. See, if it is lying in the bank account for 7 years, it may have earned interest. That interest does not belong to the company. So the company will have to deposit that in IEPF. We will see that shortly. What are the specific credits and how the fund is to be utilized, along with interest. Now, if the person has not claimed the dividend at all, the company may also transfer his shares to the unpaid to IEPF. But if the company has, if the investor, shareholder, has claimed dividend for any of those years, in that 7 years, if they have claimed for just 1 year, then shares will not be transferred to IEPF, but yes, whatever is the unclaimed dividend for 7 years, that will definitely be transferred to the IEPF. So we will transfer unpaid dividend or unclaimed dividend, and along with interest. Any person claiming the amount may apply to the company for money claimed. This simply means that if your money is transferred to IEPF, if your shares are transferred to IEPF, you need not worry that money still belongs to you. Just simply apply to the government and just apply to the company, and they will arrange for the money to be given from the IEPF. You can give small proof that you are the owner of that share, and without paying any money, it is free. You will get back your shares from IEPF. Okay, so yes, along with the dividend interest, your shares may also be transferred, but it is a simple procedure. You can show document proof and you can get back your shares. From over here, we discussed another important point, that in case you have claimed dividend from for any of these years, okay, then in that case your shares will not be transferred, but the dividend which is unclaimed or unpaid for 7 years, that will be transferred to IEPF. Now, what is the use of Investor Education and Protection Fund? What is credited and how is it to be utilized? It has a very specific use. We will be studying that. First of all, section number is important, section 125. Investor Education and Protection Fund. Now, this is a fund which is established by the central government. In case a question is asked in the exam, you need to give introduction also. So, this is a fund which is established by the central government. It is credited with specific amount and it also has specific use. What is credited? We will be studying that shortly. The amount, the accounts are to be audited by the Comptroller and Auditor General of India, since it is a fund managed by the government. Because it is a fund, there is a lot of money involved, you also need to properly audit the accounts. So the accounts will be audited by the Comptroller and Auditor General. Audited accounts and the report shall be submitted to the central government. So these are pointers which you have to remember for exam. In case a question is asked on IEPF, you will not just start writing what is credited and how it is to be utilized. First, give some introduction. What are the points that we discussed? It is established by the central government. It is credited and it has specific use. If there is a lot of money involved, that is fund, you also need to get the accounts audited. Once the accounts are audited, then the audited accounts and the audit report shall be submitted to the central government. Now, let us see what is credited. We will credit the fund with the government grant. Central government may give some grants so that the money can be utilized for education and promotion of investment activities. Donation which is given by central government, state government or other companies, maybe by a foreign company, foreign government. We will credit the unpaid dividend. This is the main purpose. We will credit the unpaid dividend. Interest and other income from investment. See, if money is lying in this account, it will definitely earn interest. So that interest will also be credited over here. So the unpaid dividend which was lying in the unpaid dividend account for 7 years, after the 7 years are over, the dividend amount along with interest will come here. Now this fund, we don't know when money is to be paid. So this fund will also not be kept idle. The money in this fund will also be invested. Whatever interest or whatever money that you are earning, any income from the investments, that will be credited over here. Application money due for refund. Now we had received the application money, but the minimum subscription was not subscribed. We did not meet that criteria. Law says that you have to refund that money, section 39. But if the money is lying with a company, then in that case, the company cannot keep it with himself, with itself. It has to transfer to IEPF. Matured deposits, matured debentures. Debentures deposits have matured, but we are not able to find the person to whom the money is to be paid. Then the amount will be transferred to Investor Education and Protection Fund. The interest on the above. Sales proceeds from fractional shares which were issued at the time of bonus, merger, acquisition, which are unclaimed for a period of more than 7 years. So at the time of bonus shares, we give, let's say, 1 share for every 3 shares held. Sometimes there is a fraction created. You cannot exactly convert your holding in that ratio. So those fractional shares may be sold and the sales proceeds may be credited over here. Generally, if those fractional shares are sold, that money is to be given to the holder. But if you are not able to find him for more than 7 years, then the amount will be transferred to IEPF. Any unpaid or unclaimed redemption proceeds of preference shares. Now, preference shares have to be redeemed. You cannot issue irredeemable preference shares. Maximum period is 20 years. So, if we are redeeming, but that other person to whom the proceeds are to be paid cannot be traced, maybe his account number is wrong, maybe he has changed his address, we are not able to credit that amount. So that unpaid or unclaimed redemption proceeds for more than 7 years will also be credited to IEPF. Shares whose dividend is unpaid or unclaimed. So along with the dividend, we will also transfer the shares, but the shareholder need not worry. By giving some proof, he can get back his shares, any other amount. So after crediting all this, let's see what is the fund used for? How will it be utilized? Refund of unclaimed dividends. See, if money is credited, money will be utilized for that purpose only. So unpaid or unclaimed dividend, application money, matured deposits, matured debentures, interest. See, we had credited the fund with that amount. Deposits were credited, debentures were credited, interest, unpaid dividend was credited, application money. Since you had credited that purpose, now people are coming to claim it, you will give it from this fund only. Distribution of disgorged amount. Disgorged amount means any amount which is earned from unlawful activities. Let's say that the officers, they committed some fraud, and because of that they earned unethical profit. Now the person who is affected by that, the aggrieved party, is claiming that loss from the company. So that company will compensate him from this fund, and then later on they can take action against the employee or officer who was responsible. Reimbursement of legal expenses in pursuing cases. Sometimes we have to fight cases, we have to defend ourselves, and in case it was not the company's fault, then the court may ask that yes, you can use the money lying in IPF for defending your case. You have to pay the lawyer's fee, court fees, etc. So we can utilize this money. Promotion of investor education and protection, like you must have seen on TV, mutual funds sahi hai. Mutual funds are subject to market risk, but yes, mutual funds sahi hai, it helps you to earn good interest. So creating awareness. Now IEPF, if you visit the website of IEPF, you will see it flashes that don't pay money to brokers who claim that they will get your shares. It is a process free of cost. Just show us proof and you can claim the shares. Don't give money to brokers who claim that they will get the shares for you. It is a free process. So to make people aware of that, we need to spend money, we need to use social media, radio, television, so money can be utilized from here and any other purpose. So yes, students, you need to memorize all this. It can be asked in the exam mostly as a theory question. These are provisions of section 127. Punishment for failure to distribute dividend. The company has declared dividend. It has to pay within 30 days. What if the company does not pay dividend, or the warrants are not posted within 30 days of declaration of dividend? Then the director and company shall be liable. But before that, once the dividends are declared, it becomes a debt payable by the company. You have to pay it within the time limit. If you have not paid, or you have not posted the dividend warrant, see, posting is important. Whether it is received within 30 days or not, that is not the condition. It may so happen that you have posted within 30 days of declaration of dividend, but they have received after 1 month, after 2 months. That doesn't matter. You have to post within 30 days. So the dividend is not posted, the dividend is not paid, warrant is not posted within 30 days. Then in that case, every director who was aware of the default, and the company shall be liable to pay penalty. Now the company will have to pay that amount along with interest at the rate of simple interest at the rate of 18% per annum. The interest will be calculated for the period of delay. The officer, the director, he will be liable for imprisonment, which may extend to 2 years, and fine at least 1,000 rupees for each day of default, for each day during which the default continues. So he will be liable for imprisonment, which may extend to 2 years, fine at least 1,000 rupees for each day of default. So this is the penalty which will be imposed. You have to remember these penalty provisions. Normally I don't stress on students remembering this, but over here I would insist because a question is very frequently asked in section 127. The last part is exceptions under section 127. Every time you cannot blame the company for non-payment. Sometimes it may happen that the dividend could not be paid due to operation of any law. That is, we were not very sure who is the legal owner. If X dies, now we are not sure who is the legal owner, or maybe by the court orders you're not able to pay the dividend. That does not mean that the company has defaulted. Company is not liable. Section 127 will not apply. Shareholder has given direction regarding payment of dividend, like you deposit the dividend in my bank account, but he gave incorrect bank details. Person got married, name was changed, she updated in the bank's record but did not inform the company. Now the company is sending the dividend in the earlier name. It got rejected. Now in this case, the company is not at fault. The most important requirement over here is that the same should be communicated to the shareholder, see that we are trying to deposit dividend but we are not able to do so, that inability, that fact should be communicated. Only then the company can escape from the liability under section 127, otherwise the company will be liable. So it should be communicated. Sometimes there is dispute regarding the right to receive dividends, so maybe there was no will, okay, person died and his sons, they are fighting over the ownership. Sometimes you're not able to decide the true owner of the shares. In that case, dividend will not be paid. Dividend has been lawfully adjusted. This is very frequently asked in a case-based question. It is lawfully adjusted against any sum due from the shareholder to the company. Now, let's say the company had to recover calls worth rupees 60,000. They had to recover call money 60,000 and they had to pay him dividend, let's say 20,000 rupees. So now the company will not pay him any dividend and instead they will adjust the entire money against the calls receivable. So you can adjust it against any sum due. Any sum due means it can be anything. I just took an example of call. For any other reasons, the inability to pay or post dividend warrant was not due to fault of the company. So it was not the fault of the company that they could not pay. In these circumstances, the company will not be liable. They will not be subject to this penalty. All right. So students, with this, we come to an end of our chapter on declaration and payment of dividend. We completed the entire chapter. We covered all the sections in just 2 pages. That is the beauty of Chartbook. If you have not yet ordered the Chartbook, then do visit my website TheoryMastersLearning.com now. Okay, after this we will discuss accounts of company. Yes, let us discuss accounts of company. Again, an important chapter for exam. As I always keep saying, units 5, 6, 7, they are extremely important for exam. You have to revise them before you revise the other chapters. All right, so let's get started. Let us discuss one very interesting topic, accounts of company. As I always say, students, the last 3 chapters according to me are very important for exam because most of the times questions are from those units only and you can expect 1 or 2 questions from these 3 units. Case-based question, theory, MCQ, case-based MCQ, anything can be asked. Now, in accounts of companies, we are going to discuss what are books of accounts, how are they to be maintained, for how many years are they to be maintained, can we order reopening of the books, what is NFRA, what are the other documents that the company needs to maintain. So everything related to accounts, books, other papers, documents is covered under this chapter. So accounts of company, I have a small table for you. It covers most of the basic concepts. What does a company need to maintain? Company shall prepare books of accounts. Books of accounts will include books and records maintained for the goods sold, goods purchased, cash received, cash paid, records of asset, liability. These are the books that the company will maintain. Company will also maintain other books, papers, documents, vouchers, other supporting documents, financial statements. Yes, the company shall maintain financial statement. Now that we are on the topic, let us understand what is included in financial statement. Now, financial statement is discussed under section 2, clause 40. This is important from the definition point of view. Sometimes a 2-mark question is asked, define financial statement. So financial statement will include profit and loss account or income and expenditure account, as the case may be, depending on the type of company, whether it is profitable or non-profit organization. It includes balance sheet, cash flow statement, statement of changes in equity, any explanatory note. But if you are a one-person company, small company, dormant company, private company, which is a startup, then it may not include cash flow statement. So that is one small privilege given to small company and one-person company, dormant company. Otherwise, the financial statements of all other companies will include profit and loss, income and expenditure, balance sheet, cash flow statement, notes to accounts, and statement of changes in equity. Why is cash flow exempt? Because it's a very tedious task to prepare the cash flow statement, and sometimes they don't have so many transactions. Okay, these dormant companies and small companies may not have many transactions. So yes, there is a small exemption to them. Maintenance of books of accounts, they will be kept at the registered office of the company. So books shall be prepared. They shall be kept at the registered office of the company, or the board of directors may keep it at any other place that they decide. It's only thing that you should inform the ROC within 7 days that this is the place where we have kept the books of accounts. So you can keep it at any other place in India that the board of directors may decide. Within 7 days, just inform the ROC. What is the time period for which you should preserve the books? The book should be preserved for a period of 8 years. But what if my business is only 4 years old? Then in that case, you need to preserve the books for all the 4 years. Inspection. Who can inspect these books, documents, other papers? The books, documents, etc. can be inspected by the directors. They are open for inspection by directors only. However, certain other persons like registrar of companies, authorized officer of the central government, or officers of SFIO, that is Special Fraud Investigation Office, they can also inspect. Now, under what circumstances will they inspect? See, maybe they are suspicious or they have received some kind of intimation from the other person that these accounts need to be inspected. Yes, in that case, if they are doubtful as to the credibility of the account, then they may inspect. So registrar can inspect, authorized officer of the central government or officer of SFIO. In case of failure to comply with these provisions, you will be subject to penalty of 50,000 to 5 lakhs. So students, here we have also covered all the penalties so that it is easy for you to remember them. Reopening of books of accounts on courts or tribunals order. Sometimes when we feel that the transactions are fraudulent, see, I have mentioned it over here. Why will you ask for reopening of the books? See, under normal circumstances, once the books are closed, they are approved by the board, then they are also approved by the shareholders in the general meeting. Then after that, you will not make any changes to the books of accounts or the financial statements. But if there is, if we feel that the accounts are prepared in a fraudulent manner, so this is the keyword. If you feel that the accounts are prepared in a fraudulent manner, and if you feel that the affairs of the company are mismanaged, thus casting a doubt on the credibility of the financial statements, you cannot rely on the financial statements, then in that case, you may ask the company to reopen the books, recast the books. The court or tribunal may pass an order in case an application is made to it either by the central government, income tax authority, SEBI, any other statutory regulatory authority, or any other person. So if they request, then yes, we may reopen the books. They will apply to the court or the tribunal, and the tribunal will ask the company to reopen, recast the book to make the corrections. What are the reasons we have mentioned over here? The court or the tribunal will pass an order if they feel that the accounts were prepared in a fraudulent manner, affairs were mismanaged, thus casting a doubt on the financial statements. Notice will be served to the applicants. Applicants in this case are the central government, income tax authority, SEBI, any other statutory body. Notice will be served to the applicants in case they have any representations. We will take that into consideration and then pass an order to either revise or reconsider the accounts. The accounts so revised or reconsidered shall be final. So the revised or recast accounts shall be considered to be final. All right, let us proceed. Maintenance of books, accounts, and other documents in electronic form. This is important because of the amendment. Now we can maintain books, records in either physical form or electronic form. And in case you're maintaining the records in electronic form, then you need to consider the following. It is optional and permitted. See, small organizations, they still prefer to maintain the books in the physical form, but a bigger organization, yes, they would like to shift to the electronic medium. So it is optional, it is not yet compulsory. It is optional, it is permitted, but these records should remain accessible in India. It should be that the servers should be maintained in India, and the records which we are maintaining should be in a legible form. It should be in the same form that you're entering data. It should not be that you have entered data in a particular format, but the output that you get in is in a format or a language that is not comprehensible. This is an important point because it is an amendment. You can use the accounting software providing an audit trail, edit log of every change. You may use whatever accounting software that you're comfortable with, like Tally, ERP, or you may have your specialized software designed for your kind of business. But whatever electronic software that you're using must provide an audit trail. Audit trail means you should be able to trace the entry right from the beginning till the end. The person who has entered the details, in case it has been altered, then who is the person who has altered it, who has made the changes, who has authorized those changes. So we should be able to keep a step-by-step record of every entry that is made in that accounting system. So you should be able to trace it from the first step till the last step. In case there is any change, in case you are making any edit in any particular entry, then who has initiated the change, what is the change mean, and who has authorized the change, all those details should be mentioned. It must remain in the original or similar format. So it is okay that if you enter data in a particular format and you get it in a tabular form or a graphic form, if it is if the outcome is in a better format, then that is totally acceptable. Like you are entering basic data and you're getting it in a report format, that is fine, but it should be in a similar format. It must remain complete and unaltered. Yes. It should be displayed in legible form. Legible means a form which is understandable. It must be such that there is a proper system for storage, retrieval, display, printout of electronic records. So you must be able to maintain, retrieve the records, and you should be also able to take a printout of the record. Maintain periodic backup. Generally, backup is not maintained at the place where the data is kept. It is to be maintained at some other place. In organizations, normally on weekends, the IT department will take backup. So I remember when I was working, the IT department would ask us to keep the files in a common folder, and that folder would be backed up. Okay, so every weekend, they would take backup of the data. In case a question is asked in the exam, you are expected to write all these points. So highlight them and mark them as important for exam. Next, we have approval and signing of financial statements. So we know what is included in the definition of financial statement, what is considered as a financial statement. Now, who will sign and how will the financial statements be prepared? So let us first, I think we should discuss the financial statements should give a true and fair view. These are the keywords. So I'll highlight the keywords which should be present in your answer. They should give a true and fair view of the state of affairs of the company. They should comply with the accounting standards. Now, what is a true and fair view? I always say that true and fair view means जो लिखना चाहिए था वो लिखा है, जैसे लिखना चाहिए था वैसे लिखा है. It means whatever should be written is written. So all the material important information is provided. It is complete in all respects. And जैसा लिखना चाहिए था वैसा लिखा है. It means after following all the accounting standards. So it should give a true and fair view. It should comply with the accounting standards. It should be in a form as provided for different classes of company in Schedule 3. Schedule 3 will give you the format of preparing the profit and loss account and balance sheet. So it should be in that format only. These are few other points that you should keep in mind while preparing the financial statement. At each annual general meeting, okay, so this is something which will be considered in every annual general meeting. It's an ordinary business considering the financial statements. Yes, board's report. So at each AGM, the board of directors, they shall lay the financial statements for the financial year. If the company has subsidiary or associates, then yes, we will also prepare consolidated financial statements in the same form as the original statements are maintained. They will also be laid before the annual general meeting. In case the financial statements do not comply with the accounting standards, deviation along with reasons for the deviation and what is the financial impact of the deviation shall be disclosed. Now, one very important requirement is that the financial statements should comply with the accounting standards, and if they do not, then in the financial statement you have to mention the deviation, like we are not following this particular accounting standard and this is the financial impact, whether profit has increased or decreased due to that deviation. That should also be disclosed in the financial statement. So in case a question is asked on define financial statement and state the characteristics or features, then you can write whatever you see on the screen. See this. The definition will be mentioned along with section number. You need to write this note also, on which I have marked a star. Then financial statements shall, you will write that. Signing you need not include unless they specifically ask you to. Approval and signing of financial statements can be asked as a case-based question. Generally, it's asked as a case-based question. Section 134. Financial statements, including the consolidated financial statements, shall be first approved by the board and it shall be signed on behalf of the board by chairperson if the company has authorized the chairperson, if the board has authorized the chairperson, or if there is no chairperson, or if he is not authorized by the board, then by two directors, and out of this one will be a managing director in case the company has a managing director. So the consolidated financial statements as well as the standalone financial statements shall be signed by the chairperson, but only if he is authorized by the board. And if he is not so authorized, then it will be signed by 2 directors, out of which one will be managing director, if any. It will also be signed by the CEO, CFO, company secretary if they are appointed. In case of OPC, it shall be signed by 1 director, because yes, minimum we need only 1 director. So even if 1 director signs, it is allowed. Signed statements shall be submitted to the auditor. The auditor will submit his audit report as well as the financial statements to the members of the company for consideration in the annual general meeting. So you need to remember all this, and it is easily possible through the charts. Yes, I have written everything in step format, making it very easy for you to remember the points. Guys, I hope you're enjoying studying from the chart book. If you have not yet purchased the chart book, then do visit my website, TheoryMastersLearning.com. Copy of your chart book is waiting for you. All right, next let us discuss NFRA, important for short note, that is National Financial Reporting Authority. Because of the loopholes in the Companies Act, there were many frauds or scams that took place in the past, and most of them could be blamed on the auditor as well. There were cases wherein the auditor colluded with the management and they carried on those unethical activities. So after that, the government as well as ICAI became very stringent, and they introduced a special authority, that is the National Financial Reporting Authority. What is the power of NFRA? What are the duties, rights of NFRA, composition of NFRA? That is also something which can be asked in the exam. So aim was to enforce, okay, to introduce and ensure that it is followed. Monitor what? Compliance of auditing and accounting standards. So these are the auditing and accounting standards that you need to follow while preparing the accounts, and the auditor will have to ensure that the accounting standards are properly complied with by the company. They need to follow the auditing standards while verifying, while checking the books of accounts. So NFRA, they only recommend these accounting standards. They are actually enforced by the central government. So the job of recommendation is done by NFRA. They have tried to make it stringent, slightly strict. Okay, they have increased the responsibility of an auditor. The functions of NFRA, it is, yeah, let us highlight the keywords. Okay, I'll change the ink. It is to make recommendations to the central government. So NFRA will only recommend. Finally, enforcement will be by the central government on formulation and laying down of accounting and auditing standards. So they only recommend. Then they will monitor and enforce the compliance with accounting and auditing standards. They will ensure that the auditing and accounting standards are followed by the auditing professional. They will also oversee the quality. These words should be present in your answer. They will oversee the quality. So how will you ensure that the quality of professionals is maintained? By ensuring that they attend training programs. In case there is any amendment in the act, so we organize seminars or some training program wherein they can attend and update their knowledge. So even ICAI has introduced compulsory training hours for chartered accountants who are in practice. So every year they have to attend minimum 20 hours of training and updating their knowledge. So that is something, the quality of professional is something which is ensured by NFRA. So in case a question is asked on functions, there are 3 functions which you will mention. Powers of NFRA to investigate into the matters of professional or other misconduct committed by member or firm of chartered accountant. So apart from the ICAI, even NFRA can initiate action. They will exercise the same power as it is vested in the civil code. Civil code means that they can blame you for damages caused by your conduct as an auditor. So any authority person that has suffered damages because of your wrongful statement or report, yes, then NFRA will impose penalty on the individual. They will be forced to pay damages on the individual or the firm of auditors. They will impose penalty for proved professional and other misconducts. Even ICAI takes very strict action. They may suspend you, they may debar you from undertaking audits, they may penalize you, sometimes they may even cancel your membership. So very strict actions are taken in case we find some kind of proved professional misconduct by chartered accountants. So that is NFRA. Next we have the board's report. See, the board's report, you can write down, it forms part of annual report. Okay, the board's report forms part of the annual report. Board's report is a way of communicating with the shareholders. See, shareholders give us money. Okay, they provide us their hard earned money in the form of capital. So, and the board of directors manage that money. So at the end of the year, board of directors, they feel responsible to the shareholders. So they report as to how the company is managed, what is the profitability of the company, what is the dividend that they're recommending. Okay, the dividend is recommended, the final dividend is recommended by the board of directors through their board's report, and it will be declared by the shareholders in the annual general meeting. So this is a way of communicating the overall financial position, operation, the scope of business. So let me write it over here. They want to explain it through the board's report, the overall financial position, operation, and business scope. Okay. So what is actually included in the board's report? What are the contents of the board report? It will contain web address, if any, where the annual return, as we had discussed in section 92, has been placed. The URL will be given you. If you're viewing the soft copy of the board report, just click on that and it will be directed. It will direct you to the annual report. Number of board meetings that were held in a year. So along with the date, the number of directors who had attended the meeting, directors responsibility report, details of fraud reported by auditors. So in case frauds are reported by the auditors, the board of directors will give a reply as to what action have they taken against this fraud. So it means that the audit report will be submitted before the board's report. The date of the audit report will be before the date of the board's report. Comments by the board on remarks made by auditor. So whether the auditor has given a qualified report or an adverse report, or what are the comments given in the audit report, a reply to that will be given by the board of directors through their report. Again, it simplifies it signifies that the audit report will be submitted before the board's report. Company's policy on the director's appointment and the remuneration. What is the company's policy? How do they select? Is a nomination and remuneration committee in existence which suggests the name of the directors that can be persons who can be appointed as a director? So what is how do you appoint the director? What are the criteria? Like, do you see the qualification and the companies in which he's a director? So all that will be mentioned over there. Particulars of contracts of arrangement with related parties, material changes affecting the financial position. So in case there are certain material changes which are affecting the financial position, they may have taken place after the closing of the financials. So maybe they want to highlight it, they want to discuss that there are certain achievements which they want to bring it out to the shareholders. Conservation of energy, technology absorption, develop and foreign exchange, development, implementation of risk management, CSR policy and initiatives, where they are spending, what are the initiatives they are taking for CSR, what are the new businesses that they have launched, are the board meetings conducted on time, are there any other grievances, and how have they addressed. So it is a communication by the directors, they are communicating with the shareholders. Then we have the corporate governance report. Corporate governance means the manner in which a company is governed. Good governance implies that you have policies in place, you have more number of independent directors on your board, you have a code of ethics, you have a whistleblower policy. So there are certain things which make the employees comfortable, the shareholders comfortable. So how are you managing the company to the best of your ability? It aims to improve the company's image, efficiency, effectiveness, and social responsibility. So, taking care of the employees, their welfare, their family, CSR initiatives, all these, and you're caring for the environment. These are good governance. Company's code of governance, board of directors, the composition will be discussed over here. Audit committee and other committees, their formation will be discussed, their members will be pointed out. Meetings held in the year, the annual general meeting, board of directors meeting, when was the other meetings held, the resolutions that were passed, and we will also mention the date of the meetings, people who had attended the board meeting. Materially significant related party transactions, non-compliance by the company, if any, date of book closure, it will be for declaration of dividend, dividend payment date, market price, plant location, and many other things. Okay, so this is something, these are the 10 points which you can remember from exam purpose. Otherwise there is a lot of other data also which is mentioned in the corporate governance report. Again, this also forms part of the annual report. Then we have corporate social responsibility. I'm not covering it over here because it is a very vast topic. There is a QR code. You can scan that. I will also leave a link of corporate social responsibility. I have covered the amendments as well as the explanation in that video. Please go and watch that video. It covers CSR extensively. Last, we have section 138, internal audit. Now, what is the work of an internal audit and how is it different from statutory audit? See, statutory auditor only goes through the books of financial statements to determine whether the financial statements show a true and fair view of the state of affairs of the company or not. They don't do an in-depth analysis of the systems. They don't do an in-depth analysis of any particular procedure. All that work is done by the internal auditor. Internal auditor and statutory auditor, they are two separate persons. Statutory audit cannot conduct internal audit of the same company. Now, internal auditor does an in-depth analysis of the systems. Basically, like when I had joined the corporate, I was working in the internal audit department only. You go deep into the system and you try to find out the loopholes. So you pick up any process in the company, try to understand the process, try to understand how the data moves in that process, what are the loopholes, what are the possible frauds that can take place, and you try to address those loopholes. You prepare a report, discuss it with the management, make changes, submit this report to the statutory auditor, and if he feels he can incorporate few points in his statutory report. Who can be appointed as internal auditor? So a chartered accountant, a cost accountant, or any other professional as decided by the board can be appointed as the internal auditor of the company. He may or may not be an employee. You can have your own internal audit department, and in apart from that, you can also get the internal audit conducted by an external internal auditor. Internal means someone who comes from outside, and your internal audit department is working continuously in the organization. So a chartered accountant, cost accountant may or may not be in practice, may or may not be employee of the company, can be an internal auditor. Listed companies have to compulsorily get internal audit done. Unlisted company will get the internal audit done only when their outstanding deposit is 25 crores or more during any time in the previous financial year, or the word is or. So these are not cumulative, these are alternative requirements. Paid up share capital is 50 crores or more. Outstanding loans from the banks, public financial institution exceeds 100 crore or more. Turnover exceeds 200 crore or more during the previous financial year. See, I've written it in sequence. So we start with 25 crores, double it, 50 crores, double that, 100 crores, double it, 200 crores. So these are the limits that you need to memorize. They will ask you whether they will give you a particular company, they will mention the paid up capital, turnover, and you have to decide whether the company needs to conduct an internal audit or not. In case of a private company, if the outstanding loans and borrowings from banks or the public financial institution exceeds 100 crore or more, turnover exceeds 200 crore or more, if either of these conditions are satisfied, the company has to get the internal audit done. So students, these are the requirements. You have to memorize this. Internal auditor, yes, as I discussed, he does an in-depth analysis of the systems, of the processes, tries to find out the loopholes. Who can be appointed as an internal auditor, that we have already discussed. And with this, we come to an end of the accounts of company. I have tried to cover all the important concepts over here. Next, we will discuss audit and auditors. I love the chapter. I love the charts that we have prepared. So let's study audit and auditors. Let us discuss a new unit, audit and auditors. This is my favorite unit because I love the charts that we have prepared for audit and auditors. Students, if you study these charts properly, you can actually convert them into an answer. These are not just pointers. These are actual sentences which you can comfortably write in the exam. Okay. So follow these charts properly. Everything is covered. You will realize that all the important sections are covered, and if I feel that at this point you need some extra information, I have included that also. Like, see over here, if the company is required to constitute an audit committee, not required. So if I feel that yes, at this stage you need to know something extra, I have included that also in our revision sessions. So beautiful charts prepared for appointment for audit and auditors, and I always tell my students that you should start revising in the reverse order. So cover payment of dividend, declaration and payment of dividend, accounts of company, audit and auditors first, and then you go to management and administration, followed by the earlier chapters. Now let us discuss audit and auditors, something which is common to audit as well as law, but even though it is a common topic, it is important for law. Many questions are asked. In fact, in every attempt you will get at least 1 or 2 questions from this chapter. So without wasting any time, let us jump into the audit and auditors chapter. Okay, yes, I have mentioned all the important section numbers over here. You need to remember these section numbers at least. Now, who can be appointed as an auditor of the company? So what is the qualification? What is the eligibility of auditor? If you wish to appoint an individual as an auditor of the company, then he should be a chartered accountant practicing in India. If you wish to appoint a firm, then in that firm, majority of the partners practicing in India must be chartered accountants. Now, the firm where I was doing my articleship, in that firm, there were many partners who were chartered accountants, but there were certain partners who were like, I remember one of them was a company secretary, one of them was a tax consultant. So it is not compulsory that in a firm you will have all partners who are chartered accountants. What law requires over here is that if you want to appoint a firm as an auditor, then majority of the partners who are practicing in India should be chartered accountants. Okay, so firm where majority partners practicing in India are chartered accountants. Majority means more than half of them. If you are appointing a firm, you can also appoint a limited liability partnership, LLP. You will notice that many of these audit firms, they have now converted themselves into LLP because of the features of LLP. Limited liability, yes, limited liability, separate legal entity. So because of these benefits, they have now converted in their existing partnership business into LLP. If you are appointing LLP as an auditor of the company, then in that case, only the partners who are chartered accountants can act and can sign the audit report. Okay, only those partners who are chartered accountants can act as an auditor, and only they can sign the audit report. So yes, you can appoint an individual chartered accountant in practice as the auditor of the company. You can appoint a firm, the majority of them are practicing in India, but they are chartered accountants. And if you are appointing a firm, then you can also appoint an LLP, but in that case, only the partners who are chartered accountants can act as an auditor and can sign the audit report. So this is eligibility and qualification. It is important for exam. It can be asked as a theory or maybe a case-based question. Now, if I want to appoint an auditor, the company has just been incorporated. What are the provisions for appointing first auditor covered under section 139 subsection 6? Yes, you need to remember this section number. Appointment of first auditor of the company. Now, the first auditor, see, these are steps which you need to follow. They are exact sentences which you can write in the exam. The board of directors, who will appoint? The board of directors shall appoint the first auditor within 30 days of registration of the company. So what are the keywords? Board of director will appoint the auditor within 30 days from the registration of the company. So when you try to memorize this, how will you memorize? You should see, when you see things in color, no, it is easy to remember. So board of directors shall within 30 days of registration appoint the first auditor. In case the board fails, it did not appoint the first auditor, it will inform the members regarding such failure, and then the members will appoint the auditor in the extraordinary general meeting within 90 days of receiving that information. So did you notice everything is properly given in steps and sentence form? So let us revise it. Board of directors will appoint the first auditor within 30 days of registration of the company. In case the board fails, they will inform the member, and the member, after receiving this information, will call extraordinary general meeting and appoint the auditor within 90 days of information. The auditor so appointed shall hold office till the conclusion of the first annual general meeting. So you need to write this common point also. So there are 4 points that is sufficient for a 4-mark question. You will also write the section number, which will definitely carry marks. This was appointment of the first auditor in case of a normal company. But what about appointment of first auditor in case of a government company or a company which is either owned, controlled directly or indirectly by central government, one or more state governments, partly by central, partly by state government? So these are the provisions which apply to appointment of first auditor, section 139 subsection 7. The Comptroller and Auditor General of India. So this is to be highlighted. If you have the chart book, please highlight along with me. The Comptroller and Auditor General of India will appoint the first auditor within 60 days of registration of the company. So CNAG will appoint the first auditor within 60 days. But what if the CNAG fails? Then they will inform the board, and the board shall appoint the auditor within the next 30 days. So as soon as they receive information, they will appoint the auditor within the next 30 days. If the board fails, Then they will inform the company, who will call extraordinary general meeting and appoint the first auditor within 60 days of receiving the information. So let us revise. CNAG will appoint the auditor within 60 days of registration of the company. If CNAG fails, board will appoint within the next 30 days. And if the board fails, then they will inform the members, and the members will appoint the auditor within 60 days from date of information. Auditors so appointed will hold office till the conclusion of the next annual general first annual general meeting. Okay. So these are the 4 points which you will write in case of appointment of auditor in case of government company, or as I inform, a company which is either owned, controlled directly or indirectly by central government, one or more state governments, partly by central, partly by one or more state governments. All right, I want to appoint an auditor. That was appointment of first auditor. Now let us go through the provisions for appointment of subsequent auditor. Now, in case of other companies will include companies which are not government companies. Okay, so in case of other companies, this is discussed under section 139 subsection 1, and in case of government company, the provisions are given under section 139 subsection 5. In case of any other company, now you need to see whether audit committee is required to be constituted. If you are a company and you need to constitute an audit committee, then what is the work of an audit committee? Audit committee is a liaison. Okay, they are like a middleman between the company and between the directors and the members. So the audit committee, they will suggest that these are the auditors, and we have selected this auditor. This is one name which they have zeroed in. So you can appoint this person as auditor of the company. So the audit committee, see how I have written the steps, they will recommend to the board of directors the auditor which can be appointed for that year. If the board agrees, everything is very happy. Okay, if the board agrees, they will recommend to the members in the annual general meeting, and the members will then appoint the auditor. It is one of the ordinary businesses, just an ordinary resolution required to appoint the auditor, and we also fix their remuneration. So what are the steps to be followed if you are required to constitute an audit committee? So the audit committee will recommend to the board. Board, if it is satisfied, they will recommend to the members. Members will then appoint. Now, what are the things that audit committee considers before recommending? So they will see whether the auditor that we are appointing has the necessary work experience, considering the type of industry, considering the type of company. So have they actually audited such type of companies in the past? What is their work experience? The team size, whether they will be able to handle the audit of such a big company. So experience, whether they are capable of, whether it is commensurate, the team size is commensurate, their experience is commensurate with the size and business of the company. So all that will be considered, and when found suitable, they will suggest the name to the board of directors. But if the board of directors does not agree, so they will refer back to the audit committee that please, we don't agree with this auditor, please suggest some other name. Now it may so happen that audit committee is suggesting some name, and the board of directors they are not happy, so they have referred it back to the audit committee, but the audit committee is adamant, no, we will stick to this person only. Then in that case, the board of directors will suggest one name, audit committee has suggested one name, we will place both before the members, and then they will decide what to do. Now, if the audit committee is like, okay, fine, if you're not happy with this, we'll change it, and then the board and audit committee agree, then in that case, it's a happy situation. They will recommend this, the name to the members, who will finally appoint the auditor in the annual general meeting and fix the remuneration. But what if audit committee is not required? Then in that case, the board will recommend to the members in the general meeting the name of auditor which can be appointed. Then the members will pass just an ordinary resolution to appoint auditor, and they will also fix their remuneration. So these are the procedure for appointment of auditor in case of other company. What about appointment of auditor in case of a government company? Very important provision, can be asked as a 2-mark question. The subsequent auditor will be appointed by the Comptroller and Auditor General of India for a financial year. It means, it says 1 year. Okay, so over here, means they are talking about a period of just 1 year, 1 financial year. If you want, I can write that also, financial year. So in this case, the auditor is appointed for just 1 financial year. In case of other companies, we will see the term of auditor. The term of auditor, he will hold office from the conclusion of that meeting in which he is appointed till the conclusion of the sixth meeting. So from the meeting that he's appointed, that is the first meeting of his office. So that is the first year. So first to second, second to third, third to fourth, fourth to fifth, fifth to sixth. This shows that in case of other companies, the auditor is appointed for a term of 5 years. After 5 years are over, you can either reappoint that auditor or you can appoint someone else in his place. Then 5 years are over, you will appoint the auditor for every 5 years. Only under certain cases, like we will study, only for certain companies, there is a provision of rotation of auditors that will apply. But if you're not covered by that section, then you can appoint an auditor for 5 years, you can again appoint him for 5 years, and so on. But in case of a government company, the auditor is appointed only for a financial year, and he will be appointed within 180 days from the commencement of the financial year. So the Comptroller and Auditor General of India shall, within 180 days from the commencement of the financial year, appoint the subsequent auditor, and this auditor will hold office till the conclusion of the annual general meeting. So whenever he is appointed, from that day till the conclusion of the annual general meeting. So only for a financial year, appointment will be within 180 days. Now, in case I wish to appoint an auditor, I will also have to consider the provisions of rotation of auditors. Now, this is applicable, you should know, only for listed companies or specified class of companies. Which companies are specified, that is given below. Okay, so these are the class of specified companies. I'm drawing an arrow so that you know we have discussed that also. So in case of listed company, you can appoint the auditor for term of 5 years. Like if you're appointing an individual, you will appoint him for one term of 5 years. After his term is over, he will be subject to a cooling period of 5 years. It means he cannot be appointed as an auditor of the same company for 5 years. After the cooling period is over, you can either reappoint him or you can appoint someone else. If you're appointing a firm, then in that case, you can appoint them for 2 terms of 5 years each. So we will not appoint them together for 10 years. No. We will appoint them for one term of 5 years. Then after that, it is open to the company whether they want to appoint him for another term of 5 years. Then the company can do so. In case the company wishes, no, we don't want to appoint him, we'll appoint someone else, the company is free to appoint someone else. So let's say that I am a company, I have appointed a firm for 5 years. After 5 years are over, I can either reappoint that person or I can appoint someone else. After those 10 years are over, then there will be a cooling period of 5 years, and that firm cannot be reappointed as an auditor of that company. They can be appointed as auditor of any other company, but not that same company. After that cooling period is over, now the company, if you want to reappoint them, you can do so, or you can appoint someone else. There are certain specified companies to which this rotation of auditor applies. So it applies to all listed companies as well as other specified companies. Let us go through those specified companies. These specified companies exclude OPC and small companies. All right. So which are those specified class of companies to which this rotation applies? So we will not consider OPC and small company, but we will consider all unlisted public companies having paid up capital of 10 crores or more. So if you are an unlisted public company, rotation will ideally not apply to you because it applies only to listed company. But if your paid up share capital is 10 crores or more, then the rotation part applies. For if you are a private company, okay, if you are a private company having paid up capital of 50 crores or more, then yes, the rotation part will apply. All the companies having paid up capital below the threshold limit, like you are not a listed company, you are not satisfying any of these above criteria, but you have public borrowings from the financial institutions, banks, or other public deposits of 50 crores or more, then rotation of auditors will apply. Okay, so this part is extremely important for exam. You need to know the companies to which, these specified class of companies to which the rotation of auditor applies. So let us go through it once again. All unlisted public companies having paid up capital of 10 crores or more. It doesn't apply to a private company, but if you are a private company having paid up capital of 50 crores or more, or maybe you don't fit into any of these above criteria, but you have public borrowings. I was just checking whether bullet points are mentioned or not, because I have written bullet points in the third point. So if you have public borrowings from banks, financial institutions, or 50 crores or more, then yes, rotation applies. If I'm not a listed company, if I am not a specified class of companies, then I can appoint auditor for 5 years, again 5 years, again 5 years, again 5 years. All right. Expected exam question. Yes, this is a concept on which I feel they can ask you an exam question. If suppose Messrs A, B, C and company, they are chartered accountants. Okay, A, B, C and company chartered accountants. They are appointed as auditor of the company. Now they are 5 years term, 5 years term. There's 2 terms they are over. Now we want to appoint Messrs A, P, Q and company chartered accountants as the auditor of the company. In this case, Mr. A is a common partner. Okay, Mr. A is a common partner. Can I appoint A, P and Q as auditor of the company during that cooling period? Answer is no. We cannot appoint A as we cannot appoint A, P and Q company chartered accountants as the auditor of the company because there is one common partner. So what we want to say is that in case of outgoing firm and incoming firm, if there is one common partner, then you cannot appoint that person in the cooling period. Now, if the cooling period is over, then company, it is up to you whether you want to appoint Messrs A, B, C and company or Messrs A, P, Q and company. It is up to you whether you want which firm you want to appoint as auditor. Okay. Then we have provisions relating to reappointment of retiring auditor. Now, an auditor retires automatically after 5 years, after his term is over. You can reappoint him, no problem. If you are not covered by the rotation part, you can reappoint that person, provided that he is not disqualified for reappointment. When will he be disqualified? I have discussed that separately later. So if he is not disqualified, or if he has not given a notice in writing of his unwillingness to be reappointed, he should not say that no, I don't want to be reappointed, and a special resolution has not been passed at the meeting appointing some other auditor or providing expressly that he shall not be appointed. They both actually mean the same. Let us discuss it now. He should not be disqualified from being appointed. All right, he should not be subject to any of those disqualifications. He should not give in writing that, see, please, I don't want to be reappointed. Then in that case, we can't reappoint him. A special resolution has been passed in the general meeting asking the company to appoint someone else instead of the current auditor, or you are saying appoint any other person except this current firm or current auditor. So indirectly you are asking the company to appoint someone else instead of the current auditor. In that case, the current auditor cannot be, or the retiring auditor cannot be reappointed. So section 139 subsection 9. And now what is section 139 subsection 10? Where at any AGM no auditor is appointed or reappointed, then the existing auditor will be considered. He will continue to be auditor of the company. So if no auditor is appointed, then the existing auditor will continue auditor of the company. That is discussed under section 139 subsection 10. This is very important for not only theory but also case-based question. The ones which I've highlighted in red are frequently asked exam questions. If you are a statutory auditor of the company, then you cannot provide accounting and bookkeeping services. It is so logical. You cannot prepare the accounts as well as audit it. You cannot conduct internal audit. Now, there were students who were asking me, ma'am, I cannot become an internal auditor of any company. No, that's not the case. If I am a statutory auditor of, let's say, company X, then I cannot be internal auditor of company X. I can be internal auditor of any other company. But you cannot be both statutory as well as internal auditor of the same company. You cannot design and implement any financial information system, because you cannot design the system and then come to audit it. You will never find out faults in the system that you have designed. You cannot provide actuarial services, investment advisory services, investment banking services, rendering outsourced financial services. Like, say, for example, you have the company has outsourced the salary computation to you, or maybe you have any knowledge portal. Okay, it's a KPO that you are providing some certain kind of knowledge to the company, financial advice to the company. You are computing the salary or taxation of the employees, you're filing their returns. So there you are providing some kind of outsourced financial services to the company. You are not an independent person. You are not independent enough to be appointed as auditor of the company. Management services, any other kind of service as may be prescribed. So if you are providing these kind of services, you cannot be an auditor. And you can also say it in the other way. If you are an auditor of the company, then you cannot provide these services. Are you getting me? So if you are an auditor, you cannot provide these services, and if you are providing these services, you cannot be appointed as an auditor. Section 144, section number is important for exam. As I already informed, it can be asked as a theory question or a case-based question. Next, let us discuss casual vacancy. Section 139, subsection 8. The term casual vacancy is not defined in law. We just have a general meaning of the word casual vacancy. Now, casual vacancy is a vacancy which is caused due to death, disqualification, which is discussed here. Where is it? Here. Yes. So casual vacancy is caused due to death, disqualification, resignation of the auditor after, yes, that is important for us, after accepting the valid appointment. So I was appointed as auditor of the company. Later, I attracted any one of these disqualifications. I create a casual vacancy. That vacancy will be filled by the board. Yes. Okay. So casual vacancy is due to death, disqualification, or resignation of the auditor. Now, if the casual vacancy is created in case the auditor is appointed by comptroller and auditor general. So you are a company whose accounts are subject to audit by the auditor appointed by CNG. This will happen in case of government company or a company which is either owned, controlled directly or indirectly by central government, one or more state governments, or partly by central and partly by state government. If you are an auditor appointed by CNAG, then the casual vacancy will be filled by CAG within 30 days of creation. And if the CAG does not fill, then it will be filled by the board within 30 days. Okay, the board will fill it within 30 days. If you are any other company, then it will be filled by the board within 30 days of creation. But if the resignation is caused due to, if the vacancy is caused due to resignation, I seriously want to know why the auditor has resigned. Okay, so in case of resignation by the auditor, yes, it will be filled by the board, it will be appointed by the board, but it shall be approved by the company at the general meeting convened within 3 months of recommendation by the board. This is important for exam students. Now, in case the casual vacancy is created by resignation, we would like to know the reason for resignation by the auditor. Why, after accepting a valid appointment, why are you resigning? What is the reason? So in that case, although the appointment filling the casual vacancy will be by the board, but that will have to be approved by the company in the general meeting, which will be convened. The meeting will be convened, it will be called within 3 months of recommendation by the board. Now we want to know why did the auditor resign and who are you appointing in his place? So you also need a confirmation by the company in the general meeting. Auditor so appointed shall hold office till the conclusion of the next annual general meeting. All right. Now, in case the auditor is resigning, it's an extremely important situation for me. I would really like to know why you are resigning. So, auditor, please file form ADT3. Okay. In case of other companies, and the provisions are separate in case of government companies. So in case of other company, auditor, please file ADT3 within 30 days of resignation. File it with the company and registrar, giving us the reasons for resignation. You tell me up till what date have you completed the audit? Have you paid the audit fees or not? What are your observations? Was there any qualification? Why are you resigning? We would like to know the reasons. So in this case, the auditor will file form ADT3. It is to be filed with the registrar and the company within 30 days of resignation. But if you are a government company, then yes, you will file form ADT3 within 30 days of resignation. This will remain the same, and it will be filed with the company, registrar, comptroller, and auditor general. This is the only thing which they have added, and that also because it is a government company. Disqualification. Okay, before that, let us go through the removal of auditor before expiry of the term. Now, in the previous case, auditor was resigning. Here, you are removing the auditor. Before, the word before is important. You are removing the auditor before the expiry of his term. Section 140, subsection 1. Now, in order to remove an auditor, you will have to call a board meeting. So, let me highlight those points for you. You will call a board meeting which will be held to decide about the removal of the auditor. maybe the auditor is not standing up to your expectation. Maybe the auditor, he had a team but many of them left, so now it will not be possible for you to get the audit completed on time. So why are you removing an auditor? Or maybe the auditor was colluding with certain employees and committing some fraud. What is the reason? So board meeting will be held to decide about removal and then removal and then authorizing the filing of application to central government. So you cannot just remove an auditor on your own. You have to obtain the approval of the central government. So the board will first convene a board meeting. There they will decide how to remove and why we should remove the auditor. They will file the application with central government citing the reasons for removal. Application to the central government will be made in form ADD2 within 30 days of the board meeting. Central government will give its approval. Company to hold the general meeting within 60 days of approval of the central government. So what is the sequence? First, call the board meeting, apply to the central government. Central government will give its approval, and within 60 days of approval, you will hold a general meeting with your members. Pass a special resolution at the general meeting, give reasonable opportunity of being heard to the auditor. Here the auditor will give representation. We will circulate that representation along with notice. Here in the representation, he will mention reasons as to why he should not be removed. We will circulate that representation along with the notice. But if it is not possible for the company to circulate it along, maybe it was received late, then they will read it out. Auditor will require the company to read out his representation in the meeting. So step 1 is we called a board meeting. We decided to remove the auditor, and we also filed an application with central government. Central government application was filed in form ADD2 within 30 days of board meeting. Central government gave their approval. We immediately called the general meeting within 60 days of approval. Pass a special resolution in the general meeting removing the auditor, but you please give him an opportunity of speaking as to why he should not be removed. Disqualification of auditor. Now, under these circumstances, you cannot appoint that person or a firm as auditor of your company. This disqualification may be at the time of appointment, or it may be attracted after appointment. Okay, it is possible that the person is disqualified, therefore we did not appoint him. Or it is possible that the person was appointed and then later he contracted the disqualification. You cannot appoint a body corporate except LLP as the auditor, because it's something which requires a personal touch. You need someone with mind and conscience. Body corporate doesn't have a mind or conscience. You cannot appoint a body corporate, although it is a person in the eyes of law, but they cannot come and audit. But a firm, yes, firm is not separate and distinct from the members, from the partners who have formed it. So therefore, we can hold the partners liable. But yes, now we are allowing LLP because of the best features that it offers: flexibility of partnership and limited liability of a company. You cannot appoint an officer or employee of the company. See, officer or employee receives remuneration from the company. They will not be independent and unbiased. They will never say against the company. They will never go against the person who's paying them salary. So they are not unbiased, they are biased. We cannot appoint them as an auditor. Any partner or employee of the officer or employee of the company. Now let's say Mr. E is an employee of the company. He is also a partner in a firm. Okay, he's a partner in a firm. That partner cannot be appointed as auditor of the company. Okay, partner of that firm, any partner of that firm cannot be appointed as auditor of the company, because Mr. E can easily influence them. Person who himself or his relative or a partner is holding any security or interest in the company. Interest word is used when there is no share capital. You are holding either in the company or holding or subsidiary or associate. If you are holding shares in the company, if you are holding securities either in the company, holding, associate, subsidiary, you cannot be appointed as auditor of the company. But I think this is unfair, no? You or your relative or your partner, you cannot hold security. Why punish the relative? So law has given some relaxation. Your relative of the auditor can hold securities in the company of face value rupees 1 lakh up to rupees 1 lakh. So yes, your relative can hold securities in the company up to face value rupees 1 lakh. Now in this case, what if at the time of appointment, my relative held only securities worth 60,000 rupees. So I was appointed as an auditor. Later on, he purchased more securities and now his holding is 1,20,000. The auditor will have to remedy this defect in 60 days. Okay, I will have to remedy this. I'll have to tell him that, relative, see, because of you, I will be disqualified. Please sell these securities, transfer them, remedy this defect in 60 days, else you will be disqualified from being appointed as an auditor of the company, and that will create a casual vacancy. Theory, case-based question are generally asked on all these provisions. So disqualification is very important for exam. Many a times I have observed that they have asked a case-based question on this, and this is important because it has been frequently asked. Person who himself or his relative is indebted to the company or subsidiary or associate subsidiary of the holding in excess of rupees 5 lakh. So let's say that Mr. X owes 7 lakh rupees to the company. He cannot be appointed as the auditor of the company. He owes 7 lakhs to the associate. He cannot be appointed as the auditor of the company. And fellow subsidiary is also included over here. Any person who has given guarantee or security in connection with the indebtedness of any third person to the company or subsidiary or associate or holding or subsidiary of such holding in excess of rupees 1 lakh. So can I say in simple words, if you are a surety, you have given guarantee of more than rupees 1 lakh, you cannot be appointed as the auditor of the company. So let's say, for example, that H has given some loan to S. I'll use some different letter. H has given loan to P. S acts as a surety. H, don't worry, P will pay the money. If he doesn't pay, then I will pay. You're acting as a surety. You cannot be appointed as auditor of the company on to whom you have given a guarantee. So he cannot be appointed as an auditor of H. So any person who has given guarantee in connection with the indebtedness of a third person to the company, so you cannot be appointed as auditor of the company. Now, what is the logic? See, you will never be unbiased because you have given guarantee for some other person. If that person defaults, I don't think that you will ever want to disclose that to the holding company. You will always know it is going proper. There is some kind of financial interest, so you cannot be appointed as an auditor. A person or a firm who, whether directly or indirectly, has business relation with a company or subsidiary, holding, or associate. So you have sold goods to the company, you have some kind of financial transaction, you have given loan to the company, you cannot be appointed as auditor. Person whose relative is a director or employment of the company as director or KMP. Now let's say, for example, I'm just highlighting this separately. Person whose relative is a director, maybe a nominee director, an executive director, he's in employment as a whole-time director, or maybe a KMP, you cannot be appointed as auditor. So let's say, for example, that Mr. X and his relative Mrs. X, wife, okay, wife is relative. So wife is the director of the company. So Mr. X cannot be appointed as auditor. Wife is a whole-time director of the company. X cannot be appointed as auditor. Wife is a KMP. X cannot be appointed as auditor. Wife is just a store manager. X can be appointed as an auditor because a storekeeper, okay, I'll use the word keeper because you will say my manager is also included in the definition of KMP. Okay, she's a storekeeper or she's just a regular employee. Then yes, Mr. X can be appointed as auditor of the company. We don't see any problem in that. But you know what, students, from this, I remember one incident. A colleague of mine, okay, when I was doing my articleship, my friend, we were auditing a company and her father was at a very good position in the company. My friend was not given that audit. She was not a part of my team. Why? She was a part of the team, but for that particular audit, she was not included just because her father was an employee. So she was sent on some other audit. Then we again met on some third audit. But I just remembered that her father was an employee, and yes, she was a part of the audit team, but for that particular audit, she was not a part of the team. So yes, these things are very practical. They happen. Person who is in full-time employment elsewhere. You are working 9 to 6 in a bank. how will you audit my company? Okay, you are working in a corporate 9 to 9. How will you find the time to audit my company? You're not qualified. Person who is an auditor in more than 20 companies, see, I am not superman or superwoman. I cannot audit 50 companies, 100 companies. There is a maximum limit of audits that you can undertake, but in that 20 maximum limit, it will not include OPC, small company, dormant company, private companies having paid up capital less than 100 crores. So even if your number exceeds because of these small companies, then I think it's fine. Now, this limit applies to every person. So if I have a firm having three partners, A, B, and C. So Mr. A can hold maximum 20, B 20, and C 20. So the firm can hold maximum 60 audits. Okay. Now, Mr. A is also an auditor in some, he's also holding, he's also a partner in some other firm, and there he is holding 11 audits. So in this firm now total 20, right? So in this firm he can hold only 9 audits. So if you are a partner in different firms, aggregate 20 is the maximum audits that you can undertake. So in firm 1, firm 2, we will keep adding. Now his limit is reached. He cannot accept any more audits. But yes, that number of 20 will not include OPC, small company, dormant, and companies which are private and less than, they hold less than 100 crores paid up capital. Person who is convicted by a court of an offense involving fraud and a period of 10 years has not elapsed from the date of such conviction. It means the cooling period of 10 years has not elapsed. So if you may have been convicted of some fraud, there are many occasions wherein the auditors collude with the employees, with the management. Yes, and if you have been charged for fraud, 10 years have not elapsed, so that cooling period has not elapsed, you cannot be appointed as auditor of the company. Person who either directly or indirectly renders service as provided under section 144, you are disqualified. So if you are providing actuarial services, you cannot be the auditor. If you are providing financial services, you cannot be an auditor. And if you are an auditor, you cannot provide those services. If we attract the above disqualifications, it shall be deemed to be casual vacancy. Okay. Very important. Yes, all the important provisions are only covered in Chartbook. You may be feeling ma'am is repeating this important thing many times. That's because I have included all the important concepts for last minute revision in this Chartbook. Now, in case a company and an officer of the company commits contravention of section 139 to 146, I'll just highlight it, 139 to 146, if the company and its officer has committed any contravention of these sections, then in case of company, it will be subject to fine ranging from 25,000 to 5 lakhs. Every officer in default will be subject to fine ranging from 10,000 to rupees 1 lakh. So minimum and maximum. How about auditor? If the auditor has contravened any of the sections like 139, 144 and 145. So if you have contravened section 139, 144 or 145, if the default is not willful, okay, you have not done it willfully, जानबूझ के नहीं किया है, then fine will be 25,000 minimum. Maximum, it will be 5 lakhs or 4 times the remuneration, whichever is less. So for the maximum limit, we will consider 5 lakh rupees, calculate 4 times the remuneration, whichever is less, that is the maximum amount of penalty. So let's say 4 times the remuneration comes to 4 lakh rupees. So 5 lakhs and 4 lakhs, whichever is less, that is the maximum. If the default is willful, then yes, you will be subject to imprisonment also, which may extend to 1 year. Fine, minimum 50,000, which may extend to 25 lakhs or 8 times the remuneration, whichever is less. So you will calculate 8 times the remuneration, compare it with 25 lakhs, whichever is less, that will be the maximum penalty. Minimum is 50,000, maximum you can calculate. Auditor will also be liable to refund the remuneration. See, you have performed that act willfully, you will have to refund the remuneration, pay for damages, because people rely on your statement, people rely on your reports, they invest in the company on the basis of the audit report. If because of your false statements, company, statutory body, members, creditors, they have suffered loss, then you will have to compensate. So pay the damages to statutory bodies, authorities, members, creditors for any loss arising due to incorrect statement in the audit report. Students, you will have to by heart this. There is no other way out. That is why I have given it to you in proper tabular chart format, so that you know what is the minimum and what is the maximum penalty, what is the penalty to the company officers and auditor. So please by heart this. A separate question can be asked, or they can combine two questions and ask you to specifically mention the punishment for contravention. Okay, so with this, students, we come to an end. Yes, we have come to an end of audit and auditors. We covered the entire chapter in just 2 pages, and we have also come to an end to our of the video, where we have discussed the second part of Companies Act. In this video I discussed some part of debentures, deposits, charge, followed by management administration, payment of dividend. We covered quite a lot actually. Yes, please let me know in the comment section whether you like these lectures. They are specially in English. This is your channel, you requested for lectures in English, and yes, we provided that. So visit my website theorymasterslearning.com for this chart book. We also provide lectures, test series and books for CA Foundation and CA Inter Law. I'll see you in the next video, wherein we will continue with our revision of other acts.